You're right. Dagnabbit, I did it again. Oops, I did it again. Y'all, I got 4 buttons. I got a button for this mic, a button for the sound over here, and a button for the sound over there. I can't wait to get my switcher because I can just push one button and everything opens up. Well, basically, I was just saying, "Hi, I'm Ada Kay. I am your alternate juror with an alternate personality today." Y'all. Okay, there has been a live motion today. We will be looking at the live motion, and then after that, we're going to go through a guide of who is who. Morning, Eddie. Morning, Sparkles. Sparkles, are you going to be our moderator this morning? Wait a minute. Why there. It's official. Sparkles, congratulations. I did it. Hi, Justice. Hi, how are y'all this morning? No headache this morning, y'all. Thank Jesus. But my hair is kind of where it is today. Does everything look good and sound good? I've got I got my little Highland cow there that I've not fully settled on a name yet. How is the sound? I'm trying to keep the mic a little more to my side. Does it sound good? Got my coffee, and it says, "Amen." I feel like my friend Carol Torrance, talking like this. I got about 5 different personalities. Oh, wonderful, great, wonderful, because now I can sign a little bit in this situation. Okay, so we have the judge is hearing a motion in the Karen Reed murder trial. Uh-huh. So we're gonna watch that. I am behind times, okay? I mean, they probably started at 7 o'clock my time. This chick was still in bed. I'm not muted. I can hear me, you can hear me. Am I muted? I shouldn't be. Oh, good. I was at the very beginning. Okay, 2 little bit of housekeeping to do. What we're gonna do is we're gonna listen to these motions, and then we're gonna go through who is who. And I got a hold of Brandian Church, and I printed these out, but she has given me explicit permission to share them on the live. So I'm golden. So we're gonna go through it. I do need to let you know that I have a sick puppers. She's got really bad allergies. Her nose is running really bad. She's my service dog. So I may have and I've given her some medication. So I may have to go take her potty, take her out for like 5 minutes. I'm just going to let the mods know that when I say be back in 5, excuse me, that's what is going on. And if y'all can just talk amongst yourselves until I get back, I will leave running whatever is running. So that way um, y'all can see it. She is my priority, y'all, and um, I will just make it as short as I possibly can. Okay. All right, everyone. Thank you so much for joining. So, if y'all didn't see it, I want your humble opinion. Again, what do y'all think? Are y'all liking it? I literally threw that together in 5 minutes. All right. Y'all, let's get ready to rumble. Let me start sharing screen. Thank you. Okay. We are going to see how the volume is and all this. We're going to see how I fit into this. Let's rock and roll. Oh, when we take a break, y'all, I've got to do my birthdays shout outs. I got a lot of birthdays I have to catch up on. I got my volume up as high as it will go.
What I want to start with are motions that were either
You know how
allowed
this
by
sounded,
agreement. I just
Todd?
want to make sure our record's completely accurate. And if it's not, it's my error. So motions that I have that were allowed by agreement. I may need to take 1 minute. Jim, I'll be right back.
Oops, already taken a minute. That is interesting, y'all. I'm learning to get all my, I'm learning where I like everything on my monitor. Wow, my makeup looks good today. Sorry, I shouldn't be complimenting myself.
All right, thank you. So, allowed by agreement or previously allowed by me. The motion eliminate to admit the 911 call, was there an objection to that? It is paper number 298.
There was no objection.
Yeah, I have that as allowed by agreement, so, okay. The motion for the court reporter 291 and impoundment of what is supposed to be impounded, that was allowed by agreement as well, correct?
Yes, Your Honor.
And Commonwealth filed a motion regarding Zoom as opposed to webinar, and that was allowed by agreement as well, 292.
No objection.
And motion to allow in-court identification, paper 294, that was allowed by agreement as well.
No objection.
Okay. Motion eliminated to admit the victim's photograph. I have not seen which photograph you're using, but you're in agreement that about the photograph. Is that right?
Yes, yes, that won't be an issue.
I have it as allowed by agreement. Are you using one or more, or have you not decided yet?
Just one, Your Honor, and I provided counsel with a copy of that as well as some other things today.
Yeah.
Okay.
By agreement.
All right. Thank you. 295, Jim.
Thank
you. Commonwealth's motion eliminate to admit photographs of Mr. O'Keefe's injuries during the autopsy. We had a lot of discussion with jurors about this. This motion is allowed by agreement, correct? I'm sorry, that was 296. So Commonwealth's motion eliminate to admit the defense, paper number 307. I believe this was allowed. Commonwealth's motion eliminate to admit defendants out of court statements for purposes of medical treatment and certified medical records from the Good Samaritan Hospital. The notation that I had written on this was that the defendant has no objection to the admission of statements made for the purpose of medical treatment and medical records. The court takes under advisement testimony regarding the blood alcohol testing because that's a separate issue, and we'll address that today. Is that your understanding of where we stand with this motion?
Yes, that's our understanding.
Yes, Your Honor.
Okay. Jim, that was, oh, I already said that, right? 307.
Yes, thank you.
The use of leading questions on John O'Keefe's young niece and nephew, we'll see where we stand. I think I said to Mr. Lally, jurors would rather hear from the witness than the lawyer. So let's see how it goes. And if you think that you need to switch to leading questions, please just come to sidebar. I'll give you the leeway you need, of course, based on the child's testimony or child's manner of testifying. All right, so you were both in an agreement on what I have as 316 and the defendant's motion number paper 288 regarding any reference to Aiden Kearney, aka Turtle Boy, or his pending criminal charges for witness intimidation. So both parties have agreed to not introduce this in
Turtle
evidence
Boy?
in their case in chief. If anyone opens the door, the motion will be revisited. And I think I said that I sort of disagreed with you both. I do think if witnesses testify to this spontaneously, then it comes in and it can be pursued further, but just come to sidebar.
Now,
All right, 312, Commonwealth's motion to preclude reference to any bad character or any prior misconduct of the victim or any witness. That was allowed by agreement, Mr. Yannetti?
I'm sorry, if I have a witness that can be
Oh,
impeached
yes. Oh,
based
no, that's agreed.
on honest
That was
behavior
312,
being
Jim.
dishonest, I'd want it in.
313, motion eliminate to exclude character, reputation, evidence of the defendant. You're not putting in reputation evidence, right? We talked about this, Mr. Yannetti?
Hmm.
This is a motion to exclude good character evidence. Is that
It's paper number,
by the Commonwealth?
it was filed by the defendant, and I questioned whether you intended to put in character evidence, and you told me no.
That is accurate.
Okay, so that's allowed too, Jim.
Which one was that?
313, let me just check.
That's a Commonwealth one.
It is Commonwealth's motion. It's 313, other Commonwealth
No,
date stamped, I guess, or
We're
date
gonna
stamped
find out all
23.
this. I found a roadmap.
There was no
of
objection to the
about
Commonwealth's
welfare.
motion eliminate to introduce certified records from the registry, correct, Mr.
Correct.
Yannetti?
A lot of
Correct.
notes.
All right, and then motions that perhaps were not agreed upon, but I previously ruled on. So, or I think I ruled on them. If not, these are my rulings. 297, Commonwealth's number 7. Commonwealth's motion eliminate to preclude reference and redact the manner of death contained on the victim's death certificate. And I think I said in open court, this motion is denied as to cross-examination of the medical expert, but that undetermined language will not appear. That'll be redacted from the death certificate. You'll have the live witness here to cross-examine us to that. So, Jim, that's 297.
Yes, Your Honor.
Commonwealth's motion eliminate to prohibit reference to any federal investigations, paper 317, Commonwealth bold stamp 27, to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office and or Federal Bureau of Investigations. That motion was allowed after hearing. 305 is the motion regarding chalks. We'll address that when we address the defendant's motion regarding their audiovisual person. The third-party culprit, the ruling's clear on that, not in opening. That's 320-30. I think that was clear when we talked about it. All right, so those are the ones that were fairly quick to just go through. I've got another set that are sort of in the fairly quick range. And then we'll move on to the Commonwealth's discovery type motions. So first, paper 284, defendant's motion for sanctions and exclusion of evidence based on the Commonwealth's failure to timely comply with discovery orders. Mr. Jackson, you told us at sidebar the other day that you are withdrawing that motion, correct?
Correct, Your Honor.
All right, so Mr. Clerk, that's motion 285, paper 285, withdrawn by counsel.
Sparkles.
I'm sorry, Judge.
Hope
284.
sharing is in there.
Okay,
too.
I have it as 285, but,
I'd love to get up to 20 viewers.
okay, yep, so
today.
283,
Thank you.
Fabulous.
withdrawn by counsel.
Once we hit 1,000 subscribers,
motion
I'm
eliminate
gonna
for
dye my
review.
hair color. I just don't know.
So
yet.
as defense counsel
By my mod.
plainly states, that a defendant is not entitled to be present at a view. And what I've determined here is that based on concerns for security issues and frankly distracting the jurors, the defendant will not be present with us on the view.
Do what?
And as you've stated here, that is well within my discretion.
Back
All
up.
right. Commonwealth's motion eliminate to admit defendants out of court statements as statements of a party opponent. So I think that this was one of the ones that you all agreed to. Paper 308, 18 on the top. And it's followed by paper 19 regarding the
I'll go back and watch.
the various statements made to the media, to Boston Magazine, to ABC News correspondents. So I think the defendant had said previously that you were in agreement that all these statements come in. Is that right, Ms. Giannetti?
Sorry, Your Honor. Yes, that's correct.
All right.
No, thank
So
you for
I had a
hopping in and
logistical
joining.
question
Someone likes
about,
subscribe and share.
I don't know how long
appreciate it.
the ABC News
This is going to be a fun one.
interview
Um,
is. How long is that?
Your Honor, what I can say is as to each of those, the Commonwealth's intention would be to play, to admit the entirety of the interviews, but to only play selected portions of those interviews.
All right, because what I did, I re-listened to the nearly 4 hours, 3 hours and 40 minutes of the Boston Magazine audio, and there's no objection to it from
Yeah,
counsel.
I don't know
What
why.
I listened
like I
to, it
see
made
opting out.
sense, and I didn't know how you would play a 3 hour and 40 minute
We'll see.
audio. If you think you need to, we just need time to be able to put it into the schedule.
Sure,
Okay.
but no, I don't feel the need to play the entirety of it.
Okay. I was involved in a trial once where we watched a whole movie. So just
I don't wanna do
give
that
me a
again.
heads up if you think it's a lengthy segment. But how long is the ABC interview, just in case counsel wants to go back and fill in?
I think the portions that we have are not terribly lengthy.
Ooh.
And as far as the statements are concerned, it's even less so of that.
All right. So does defense counsel intend to also
They're going to have to edit it.
play I'm trying to find out if we're going to need a whole 3 hour and 40 minutes. I need to know that. I still haven't got an answer as to how long the Dateline or ABC, whatever it was, video and audio is. How long is the
Yeah,
entire
you're
thing?
awesome, Justice.
Do you know?
You're asking me?
Either of you. I don't have that. So I didn't review it.
May I have just a moment with
Yes.
counsel?
Justice, I will go ahead and put you also as a moderator. Doesn't mean you have to act like that. Act as such right now. Sparkles, I think you were the first one on. So you were the lead moderator for now.
You're right. My memory and my belief is I
I'll
think,
go into
and
the
I
chat
can't
if you
recall
need to switch
specifically
roles,
which one is one or the other, but I think one is about 10 minutes long, the other is about 5 minutes long, and again, I would only be playing, if any, portions of the defendant's statements, not the entirety of the broadcast.
Okay.
And if there are portions that weren't played, I would expect.
So that's what I'm trying to figure out. So I'm concerned on the 3 hour and 40 minute one, which it seems to be all of it's admissible. Or there's no objection to it. And if, I just need to know if we're going to play something for 3 hours and 40 minutes. The other one, if it's 15 minutes, I don't need as much heads up.
My guess would be anything that we would want to present that wasn't presented would be in the 15, 20-minute
Okay,
category.
that's
Not 3
fine.
hours.
It's just for scheduling purposes. All right. So Jim,
Yes.
paper 309 and 308, they're the same pretty much. Those
I
are
hope
allowed
y'all
by
are sharing
agreement.
this with your group of peeps. I'd appreciate it. I will be listening to Brandy's research. this weekend. We will not be live Friday. I have to go and pick up my daughter from college and bring her home for the weekend.
All right.
Um,
And it's sort of in the
I'm taking
same
Friday off
vein.
unless
So
there's
it's again,
something
it's
dramatic
another statement of the defendant. It's the statement of the defendant at the Milton State Police Barracks that I had not seen before because it was post grand jury, and we watched it. I had the opportunity to watch what we all watched here in court last Friday, and over the weekend I watched the entire hour and a half or so of it. So you're in agreement that the statement comes in and the Commonwealth says that the Commonwealth needs some leeway to show that she was in custody after arrest for a period of time, and Commonwealth wants to play the video. I don't think we need the video. Much of it is just looking at their computer. So the video part will be out. You don't want it in, correct?
That's correct. We had
Yes.
asked for the audio only.
Yeah. Okay. So the audio only, but it needs some context. It's not just that she's sitting down having a cup of coffee with the police and makes these statements. So they're clearly voluntary, clearly unsolicited. How do you want to work that out? Can it be that this occurred at the Milton State Police Barracks on a particular date? Because if you can't work it out, then I'll decide it.
Ooh, snap it. Yeah, where's my water? My water disappeared.
Yeah, I mean, from our position, Your Honor, we don't object that the statements were made at the Milton State Police Barracks as they were. And it was in that context that she was speaking to the police at the barracks. We would object to introducing evidence that she was under arrest at that time.
Yeah, I don't think we need that. But so at the Milton State Police Barracks on a particular date.
That's acceptable.
Do you need more than that, Mr. Lally, for context?
No, Your Honor.
Okay. How is this going in?
Through the trooper to whom she was speaking.
Okay. All right.
I want to know exactly how many
Right,
lawyers
so
and how
Mr.
many people
Clerk,
are being represented.
Audio only.
4 right now.
Commonwealth.
They are
Melissa,
changing courtrooms.
testimony.
Well, barracks.
Statement occurred at the Milton State Police Barracks.
Yeah.
Still, Ally, do you
Barracks
remember the
is usually
date?
Military.
June 9th.
Barracks is usually
2022.
dormitory type.
Thank you.
Where the military
Yes.
personnel sleep is called barracks, or on a police training
Okay.
facility.
So
That is
audio
weird.
only, Mr. Clerk. Commonwealth may elicit testimony that the statement occurred at the Massachusetts State Police Barracks on June 9th, 2022. All right, so those are the fairly quick ones. Before we get to what I think are the more complex ones, or the ones that I need a little bit more argument from you on, I am concerned about discovery. So, Mr. Lally, when I was going through copies of what I had previously, the first time or one time that Commonwealth filed on March 21st of this year, a notice for reciprocal discovery and notice of experts. You then, last week, I think, filed a renewed motion for reciprocal discovery and request for voir dire of any defense experts. You asked that that be impounded. And that will be based on your motion and appears to be sort of an affidavit in support. So where do we stand with discovery?
So with reference to the reciprocal discovery, what Commonwealth is seeking is noted there are a number of witnesses listed on the defendant's witness list with no materials provided as to who these people are or what their intended testimony is. The issue with regard to experts is essentially there are 5 experts, Mr. Green, who there was an attachment to a motion with an affidavit and some materials. I think I have everything in relation to that. With regard to Dr. Sheridan, I have an affidavit and a curriculum vitae, and that's essentially it with respect to that. I just am inquiring as to whether or not there are any reports or any other sort of findings or anything post that. The other 3 experts all relate to that specific, I'm sorry. The next would be Dr. Van E, who,
Which, I'm sorry, I didn't hear you.
Dr. Christopher Van E.
Yeah.
I'm a little, so essentially there are that gentleman and then 3 individuals from this ARCA company who are all purported to be testifying in the area of crash reconstruction. None of them are crash reconstructionists. They're all biomechanical or biomedical engineers. With regard to Dr. Van E, who I've had some experience with in the past, my typical dealings with him is there's some sort of report written by him. I have nothing. I just have a CV and about a paragraph of what's anticipated as far as his testimony. The other 3 individuals, my issue is there is a report that's within the federal materials in relation to what they did. However, it's a single
In relation
report.
to what?
In regard to whatever examinations or tests or whatever that.
Does it include all 3 experts, though?
Well, so that's the issue.
Yeah.
The issue is the report is signed by all 3 individuals. So I have no idea who did what, who would testify to what, who has an opinion as to what, or what that would be. So I'm just looking for some additional information or any clarification as to what each of those respective people would be testifying to beyond just
Okay, that's not me.
all 3 signed a report.
Okay, who's arguing this for the defense?
With the court's permission, I'd like to handle the issue regarding civilian witnesses and have Mr. Jackson address the experts.
All right.
So my argument's very brief, Your Honor. We're well aware of our obligations under Rule
Okay, that was
14,
not me.
and any statements that
Pardon
we
me a
have
minute.
regarding civilian witnesses that fall under that rubric, we will turn over, and we have turned over.
But why haven't you?
No, we
Obviously, she
we've turned
is.
over what we have.
We need to go.
In our
need
view,
to
we've
train her.
complied with discovery with regard to the civilian
Hey,
witnesses that Mr.
madam.
Lally speaks about.
Don't breathe
All right.
in my-
Do you have addresses for those witnesses, Mr. Lally?
We did it. Yeah.
All right, so they need addresses, right? If there's nothing there, they need the addresses so the police can go out and interview them.
We will get them addresses by the end of the day today.
Okay. All right, so my concern was that when, Mr. Lally, when did you file your certificate of compliance?
She needs to
That
come
would
off
have
the
been,
mic.
I believe the Wednesday, not last Wednesday, the Wednesday before that.
And I had previously told counsel I would expect within 2 days of that because obviously you've been preparing this case for a long time.
Of course, yes.
But so to have Mr. Lally stand here today and say that he doesn't have all this information that you know he's entitled to, I mean, dates of birth and addresses of witnesses are pretty standard, Ms. Gianetti, especially if you have, not provided anything that they're going to say. So that should have happened a week ago.
Your Honor,
If I may defer to my co-counsel.
Well, okay. And we do have to talk about how we're going to do this at trial. Okay.
Yes.
Your Honor, I provided reciprocal discovery to Mr. Lally within 24 hours of receiving
Okay.
the certificate of compliance.
Anything about these
Oh, good
witnesses that
for
Ms.
you.
Gianetti says they have everything on?
Did a good
Yes,
job.
he's received statements from all the witnesses that we have statements for, which included their dates of birth, addresses.
How
all that
many
information.
is that, Ms. Little? How many witnesses?
I don't know off the top of my head, but every single report that we have for these witnesses that Mr. Lally has received in his witness list, he has reports for.
Okay.
And a number of our witnesses,
Your
obviously,
Honor,
are witnesses that
did
the
it.
Commonwealth has interviewed.
Right. I think I
Bad he
crossed
didn't,
out
but
much
we
of your
did. We
list when I
want
read the
to
names
know
of
how
the
good you
witnesses,
are.
right? Because they were
Oh God,
duplicates.
this reminds me of high
So
school.
we have complied with at least those obligations. And if there's any addresses that we haven't produced, I will make sure that gets done today, but he
Thank
should
you.
have the vast majority of everything.
All right,
Oh my,
anything specific, Mr. Lally, on
Anybody
the
else seeing
civilian
this?
witnesses?
other than me.
Well, just in looking at the defense witness list, there are 77 witnesses that are listed. 35 of them are on the Commonwealth's witness list, and I have statements from 4 witnesses. not including
Yeah.
experts, so that would probably make it to 9,
You're
or if
correct.
you include the investigator, 10 or 11. So there's still a substantial amount of witnesses that I don't have addresses, date of births, or any statements from,
From the state
or
side.
even what their anticipated testimony would be.
Your Honor, there's also probably an additional 10 to 12 witnesses that he has reports for from the federal materials, which include addresses, statements, that type of information.
All right. It's my view that that's still the defendant's obligation to provide. All right. Or at least acknowledge where they are. All right. Let me hear the expert response, Mr. Jackson.
Your Honor, with regard to Dr.
So,
Vanny, Chris Vanny.
All those are,
First of all, he is technically a rebuttal witness. There's a trooper named Trooper Paul that's going to be called in the Commonwealth's case in chief, and he's going to testify to some key cycle information. Key cycles are trigger events or cycling events with regard to the SUV. Chris Vanny is expected to testify in rebuttal to Trooper Paul's testimony that his Trooper Paul's analysis of the key cycles is flawed in terms of timing. And the number of key cycles that he relates back to an event that takes the SUV back to 34 Fairview. So Chris Vanny has done a similar analysis, or at least overviewed or looked over Trooper Paul's analysis and has
he
determined
doesn't look too,
that Trooper Paul's
pleased.
analysis is incorrect. So
All
we,
right.
we included his name, although he's a rebuttal witness, we included his name just to be in an abundance of caution.
All
He
right.
has not produced a report.
Do you have to at least tell the Commonwealth what he bases his opinion on, what he has viewed, what he bases his opinion on?
The exact same information, the raw data that Trooper Paul based his opinion on.
All right. So is this the first you're hearing this, Mr. Lally?
There's kind of a vague description to that effect, but again, what I'm hearing is similar to that in the sense of he disagrees with the Commonwealth's expert, but I don't have any foundation for that, or what specifically he disagrees about, or what his points of contention
Really?
would be with
Didn't
Trooper
know
Paul's
that.
report.
like I said, I'm
As
coming
far
in
as no
here
report, no basis of
like a
opinion,
juror. I have no clue who
anything
has
of that
who
nature.
what.
That's my
That
concern.
does take a toll on you.
Okay. And you've requested a voir dire
Yes, Your Honor.
of the experts? All right. We don't want to bring this witness out here early for a voir dire. So I suggest you get the information that was requested.
I'll be happy to.
If we have to bring him out, we have to bring him out.
No, I'm not looking to bring him out, and I don't think that he needs to be voir dired. He's going to look at the exact same, and I'll call Mr. Lally and explain to him what I think in a little bit more granular detail is going to be the sum and substance of his testimony. But Mr. Lally he certainly can conceive, as Trooper Paul walks through his analysis, Chris Vanny is going to walk through the exact same analysis. It's the same data set. They're both working with apples and apples. He just has a different conclusion that the key cycles are not in keeping with what Trooper Paul analyzed because he left some key cycles out. Pretty simple stuff. But I'm happy to contact Mr. Lally offline and let him know exactly what it is that
All
Ms. Vanny
right.
has a
All
problem
right. So you do that. And if it's not resolved by Monday, we will pick a date within the next week to have voir dires of whatever experts that insufficient discovery has been provided to the Commonwealth on. So let's try and work everything out. The rules are very clear, and you need to provide this information.
And I thought we had, but I'm happy to have that additional conversation. And I'll do the same thing with regard to the ARCA witnesses as well.
So is there anything specifically, Mr. Lally, that you're looking for today in response to the biomechanical engineers?
Just specifically what their opinions are and what they're based on.
And who did what?
Who did what?
Should be fairly easy to provide, Mr. Jackson.
It has been in about a 9 or 10 page report that's detailed, single spaced.
But does it say who did what? I read the report as part of the federal materials. I couldn't figure out who
Correct.
did what.
I think the
So
can
Okay,
run
I'm
the
happy
case,
to
even if you're
talk to Mr.
innocent
Lally
by
about
what
that.
is
I believe
permitted
the
and not
answer is going to
permitted.
be in sum and substance.
And then
All
the
of us
juror
work together as a
instructions as
team
well.
To come to the opinions and conclusions that are.
Both of
that
those
are
can
decided
destroy
in the
you
report. But
or
I'll be
save
happy to
you
have
when
an
you
additional
justifiably
conversation with
don't
Mr. Lally about
deserve
that.
whatever it
I don't
is.
know that I know
So if
every
you're
single
innocent, it
thing.
could
As a
bury
matter
you.
of
If
fact, I
you're
don't
guilty, I
know
could save
every
you.
single
All
thing that
in
everybody
what is
did,
permitted
who
and
put
not
what
permitted,
what nut,
and then the jury
et cetera. But
instructions.
I think by and large, Mr. Lally and I can come to an agreement about what the contours of each of their testimony would be.
Okay.
And by the way, they are accident
Exactly.
reconstructionists, so there's a.
Do you have their CVs?
I do, and so does Mr. Lally.
I do.
Anything on the CV about being accident reconstructionist?
There is listings of accident reconstructionists, but I think that's part of the Commonwealth's request for a voir dire is the qualifications. I don't think meet that standard for them to be able to testify in that area.
All right. So two things. When the two of you were working on this between now and Monday, if the Commonwealth is not satisfied in requesting a voir dire, I need to hear from the two of you whether we need to do that before the evidence really gets started, or if it can be done before the witness testifies.
Okay.
All right.
Understood, Your Honor.
All right. So Commonwealth's motion for voir dire of any witness to be asked for opinion or character of defendant or any witness. I had that this was allowed by agreement, 314, Diaz number 24.
That's agreed.
And 304, Commonwealth's bolded number 14, Commonwealth's motion for order regarding opening statements and notice of any visual aids defense intends to display to jury during opening statement. So I need to know what parties intend to put up for exhibits or for chalks, whatever you intend to put up in opening. And I know you're doing the opening, Ms. Giannetti, so I need to know what you intend to display.
Nothing.
Okay, that makes it easier. So while we're talking just briefly of openings, you had told me, Ms. Giannetti, that you thought you could get everything in 35 minutes. I will give you both 45
Oh,
minutes.
that's perfect. Yes, I'll be less than 45.
I'll hold you to that.
I know you
Oh,
will.
she's
All right,
being
so
real
Mr. Lally,
gracious.
45 minutes for the Commonwealth?
Yeah, sure.
Okay.
Very gracious. So
All
Monday, we're going to have,
And Commonwealth, do you intend to put anything up during openings?
During openings, no, Your Honor.
hour and a half of openings or less.
Okay. Commonwealth's motion eliminate for notice and voir dire of Bowden. I thought that was, we decided that there would be a voir dire regarding before the Bowden testimony comes in.
Everybody knows
I
what a
don't
voir
recall
dire
that,
is,
Your
right?
Honor.
All right. Well, Commonwealth's
Lisa's
entitled
on
to a
right
voir
now.
dire. There'll be a voir dire.
My understanding of the court's ruling as it applies to opening statements is that I cannot point the finger at a third-party culprit, but I can introduce the idea of an inadequate investigation and discuss Bowden evidence.
As long as you know what's coming into evidence.
That's perfectly fair.
Remember, I use that term competent evidence.
Of course.
That's what it has to be.
Of course.
All right. Sorry, Jim. 321, the Commonwealth's bolded 31, in case my number's not right.
Thank you.
319. So this is, we talked a little bit about this. It's Commonwealth's motion for advance notice if defendant intends to cross-examine any witness about alleged bias and request for pretrial ruling on whether the proposed evidence demonstrates a plausible showing of alleged bias. So as you well know, Mr. Lally, bias is definitely an area that is ripe for cross-examination and extensive cross-examination. I needed to know exactly what your concerns are.
And, Your Honor, I think what I would suggest might make the most sense with this is to sort of take it as it comes.
Okay.
I think it's a little difficult to put counsel in a position to, cite specific things that they wish and
We have a couple of motions where we do need to do that.
right.
But for generally with this, and because this was broad, that's why I did want to, when we had a brief hearing on this, I said that I did need to hear from you regarding specific statements. So what we're going to endorse this, Mr. Clerk, is that Commonwealth will object on a question-by-question basis. Does that work, Mr. Lally?
Yes, Your Honor.
Does that work for the defense, Mr. Yannetti?
For sure.
Okay.
Commonwealth will object.
Commonwealth will object to specific questions.
Thank you.
And Mr. Lally, if you know in advance, depending on how the testimony comes in, if a particular witness gets up and you know before any examination what your concerns are, we'll visit it before the testimony.
Understood.
Okay?
Thank you, Your Honor.
A similar motion to the defense expert issue. Mr. Clerk, I believe it's 315. It's bolded number 25 from the Commonwealth. Commonwealth's motion eliminate to prohibit defense experts from testifying regarding scientific studies or anecdotal experienced and request for voir dire. Mr. Jackson, do any of your witnesses intend to give anecdotal experiences?
I said this in the argument. I don't really know what that means, but no, in terms just the common sense knowledge of common sense definition of what that is. To my knowledge, they're not going to be talking about anything.
Okay, I think it's pretty clear what it is, but if you think they're not going to do it, if it seems that they are, then we need to know. And how about the scientific studies?
Scientific studies would not be referred to in any of their testimony that I'm going to elicit at all.
Okay.
They did some scientific studying of the material.
No,
obviously.
do you mean like learned treatises and things like that, Mr. Lally?
Exactly, Your Honor.
Yes.
They're not going to be citing to learned treatises that I'm going to elicit.
Okay. All right. That's it in my category of discovery. There's some overlap in the motions that I think the following motions may take a little bit more time, and it's sort of the somewhat complex ones. So 311, Commonwealth's bold number 21. Commonwealth's motion eliminate to admit the victim's out-of-court statements relating to his state of mind. There's sort of some overlap, Mr. Lally, that we'll get into with other statements. But so this is the Commonwealth versus Qualls, Commonwealth versus Binns, that whole line of cases. Why don't I hear you? Is there any objection to this?
We may have a moment, Judge.
The Commonwealth, we were here last, the Commonwealth was told that they need to provide with the statements or the areas they intend to introduce. They do so in this motion. They do more extensively in another motion that's sort of dovetails. And the other motion concerns the Aruba incident, the arguments between the defendant and Mr. O'Keefe, and also this Binns/Qualls type testimony.
Right, so I think our position, Your Honor, was that we need to know the specifics of what they intend to introduce. My expectation is that some of that will be admissible and some of it we won't have an objection to, but it's difficult to give either a blanket objection or a blanket assent without knowing the specifics.
Okay, but you did sort of make a blanket objection to the Aruba incident, if we
But
call
we
it
had-
that.
We had to without knowing the specifics.
So
Yeah, it does look
on
like
the
a full
second
courtroom.
page of this motion, the Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. The Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship. That goes squarely with Qualls and Binns.
Right, with regard to the
Why
text
would
messages,
she
I don't
want
believe
so
we have a
long this
basis
if
to
she's
object.
been moved to civil.
All right, so
What is
I'm
the
also,
motive?
all right, I'm also going to allow statement. Mr. Lally, tell us what the statements specifically, as best you can. Who would be testifying? What family members? Does this involve the two children?
Yes, Your Honor. So there are statements that are made by the victim to the defendant in front of each of the two children with his intention to. or
What are
statement-
they roughly?
Essentially that the relationship isn't working anymore and that he would like to break up with her, ask her to leave the house. She refuses, and this is in front of both the niece and the nephew.
All right. Ms. Giannetti, I'll hear you on that.
Our expectation is any statements that were made, allegedly made by Mr. O'Keefe to my client in front of other witnesses, we don't have a basis to object to that.
Okay, so that's coming in, and you've had the benefit of the SANE interviews for a long time.
Correct.
so-
We don't waive potential hearsay objections during trial, Your Honor, but I think generally that's our answer.
All right, so on 311, Mr. Clerk, I'm going to allow that.
Yes, Your Honor.
Okay. All right, so sort of the same. 310. All right, and the defendants is 283. It's a similar motion. So, Mr. Lally, why don't I hear you on this? So this is the one when I said there are 3 areas here as I see it. If we call it the Aruba incident, the animosity between the defendant and the victim in weeks and days prior to the victim's death, and that the defendant admitted to numerous witnesses at
about
different
now.
times that the last thing she recalls was getting into an argument with the victim. So that whole domestic violence line of cases with state of mind clearly is admissible. So why don't I start with you, Mr. Lally? Go ahead and argue your motion.
So, Your Honor, specifically, what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really 4 witnesses who have information to provide to the jury.
Do we need all 4?
Well, so from different perspectives is what I would say. So 2 of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately 20-minute screaming match or something to that effect. that
Both
goes
children,
on.
both children were present?
Yes, within the hotel room, and both indicate to that. Then you have
How old were
the
these children?
woman, Marietta Sullivan, who's involved in the incident in the lobby. And then you have her sister, who was the person who invited them on the trip in the first place.
So there's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that.
Okay.
Be right back.
What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship or the nature of his relationship with the defendant.
And those statements have been provided to the defendant?
Yes, Your Honor.
There was testimony in the grand jury regarding those statements?
There is, yes. There's state police reports as well as testimony from the witness and the grand jury.
Okay.
In addition to that, as far as statements relative to the nature of the relationship, there are some minimal statements that are made by the defendant to a couple of witnesses at the waterfall the night before. Again, those are also contained within troopers' reports and the grand jury testimony of those witnesses. There are also the text messages between the victim, Mr. O'Keefe, and the defendant, which specifically address the nature of their relationship. There are text messages from the defendant to Mr. Higgins, which again specifically address not only the Aruba incidents weeks later, as well as and being a continuing point of concern, at least from the defendant's perspective, as to the nature of their relationship. And then taking all of that sort of in conjunction with the text messages between the two that day and the voicemails messages that the defendant left on the victim's cell phone shortly after the murder occurs. And then there are further statements that the defendant makes to a number of different people,
I
whether
really
they be
wish the
troopers,
judge
whether
would
they
get
be
off that mic.
paramedics, whether they be
This is
Ms.
rattling
McCabe
my-
and Ms. Roberts, or in the presence of them, as well as at least 3 paramedics, indicating that the last time that she saw the victim, Mr. O'Keefe, they had gotten into an argument. essentially at the house at Fairview Road right before she had left. So those are sort of the totality of the sort of specific areas in the nature of the relationship that the Commonwealth will be seeking to explore through the testimony of a number of different witnesses.
Okay, who's arguing this for the defense?
I will, Judge. As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, it's difficult to, again, just give one blanket objection or one blanket assent to this. Generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the Qualls and the
Correct.
Bins line of cases. So
Correct.
I did rule that those are coming in.
We recognize that,
Okay.
yes.
You said probably.
Well, yes. Well,
Right.
Mr. Lally raised it again, so.
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what it's, what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on that. That's
well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah, so you haven't tried before me before. I would not do that. So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find pursuant to Commonwealth versus Samir. It's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth. So I will give a limiting instruction. I will welcome proposed limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the Qualls and Bins line of cases.
I
And
lost something.
I will give a limiting instruction. I'm confident the jurors will understand. So that's my ruling on that, which actually, so it would be a denial, Jim, of defendant's motion 283.
Just for the record, it's 282.
82. And that's denied. I mean, it will not go to propensity, and we can make sure of that. And the Commonwealth's motion is 310, Jim, the bold 20, and that was sort of hand in hand with the other one. All right. So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion eliminate to admit expert celebrate demonstration. I think we briefly talked about it, and I wanted to know, so are the defendants objecting to the, so your witness's name again? I read it every day for the last week.
That's okay. It's Mr. Ian Whiffen.
Yes. So about him doing a demonstration, is there an objection to that from the defense?
Letting the children testify is not something
Your Honor,
I'm fond of,
since
especially
the last time we were in court, we've had
depending
an
on their
opportunity
age.
to
What
look
are
at
the
that-
age of the
that,
children?
Yeah, I'd like to look at it, but okay, so you looked at it?
We
Do you
did,
have-
we did. It's not that long. It's maybe, I don't know, I want to say 22, 25 minutes, something like that. We'll submit on the papers and stand on the objection that we previously made, that it doesn't comport with the exactitude that we think is necessary for a demonstration, but I don't think it bears, it's not an enormous deal for us. We do stand on the objection, but I'll submit on the papers.
All right, so I'm going to allow it, but Mr. Lally, I'd also like to see it.
Of course.
Okay, so if you could get me a copy, Ms. Gilman, can you get me a copy of that before the end of today?
I think so. Yes.
All right,
Not
thank
speaking
you.
for.
Yeah.
All right. All right, so Jim, 306 is allowed.
Thank you.
All right, so the two that may take, there's three actually, but the two that we'll cover here before we get to sort of logistics and sequestration. Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive. I would submit as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a
But
witness.
why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine
That was a
on
very,
that?
very vital phone call.
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lank being involved in some sort of altercation himself, and whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, even present, involved, or had anything to do with this prior incident.
There it is.
So
Yeah, Mr.
whether or not Sergeant Lake knows or was 20 some odd years ago friendly with one member of the Albert family, or even two, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment, particularly where it's an unsustained finding and there's nothing, concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in.
Right.
So who's arguing this part? We'll take these in two parts. So we'll do the Trooper Proctor part afterwards. But Ms. Little, I did say I'd give you the opportunity to argue those two cases, but
Thank
if
you.
you want to,
the
you
mic.
can, but I'm more focused on the bias or motive
I'll
part.
just briefly address Graham and McFarland because
Sure.
I do think it's very important that we make clear that Both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously
But just let's focus on Lank first.
sure.
Okay.
So-
I agree with you. They're discovery cases. They're not admissibility
Okay,
cases.
so that issue aside, Lank has he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court's
The
attention.
Albert family appears to be
And I'm,
huge, right?
well,
Or very extended family.
well, I'm getting there. So
Okay.
the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is
Who would you intend to get, if I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lopolito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through and how?
through Sergeant Lank himself. I think we
Okay.
need to be afforded the ability to cross-examine him. Once that's done, we may need the
If
local
he
law to-
denies it, and we'll
Exactly.
figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
So you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have it. His testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our
Mr. Lally said,
cross-examination.
okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So
I'm having to follow the
all right, so
chart, y'all.
go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So
No, Your Honor.
let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So I'm not going to take any action on this right now,
Okay.
but I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your
So
Honor.
we'll see where we go with this. Okay. All right. So now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to NEI investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews
Let them
in
stay
regard to any
confused.
sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office, conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay.
in
How
relation to that.
recently? I mean, it's all recent. When was that?
That was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit as not an appropriate area for cross-examination, and particularly when it's an open investigation, there are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about, them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion, is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more, because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation,
Yeah.
why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do, and just for that specific, because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing. And to allow that sort of imprimatur of the court to allow that sort of questioning into an area that
I'm
is
catching
completely
that.
unsettled and
Obsessed.
completely
Obsessed.
there's no evidence to substantiate
I'm
other than the
catching
fact
you
that
on.
it exists without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is or that it even pertains to this case. So with regard to all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth. It's unfair to the witness to be put in that position when there's really no information available.
All right. What do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in
is-
the, hold on, is it something in the information that you've received
Yes, Your Honor.
from
And
Mr. Lally?
yes, Your Honor.
All right. So can I get a copy of that?
Yes, Your Honor.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no
I
basis for
didn't
it.
think you did.
But what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IAD, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel is talking about, that has nothing to do with IA. So the materials that the
Come on,
Commonwealth has provided, that was
breathing on that
completely
microphone.
separate investigation initiated
Please.
by the District Attorney's Office. in
Okay.
relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination,
What if they don't call Trooper Proctor
we will call Trooper Proctor.
to impeach him?
Yes.
All right, so
Oh.
be prepared to argue that. I don't know. He's on the witness list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective
hypothetically
in this
throwing it out
case.
there.
He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others.
Sometimes, but he is the primary investigator in this case. And
Wow.
I think it's very, very important for the court, and I think you noted correctly, that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend to try and open on this, Ms. Gianetti? Because I need more information.
I'm not going to mention the IA investigation in my
Okay.
statement.
All right. So, Mr. Lally, if you can get me that information that you mentioned that you
Sure.
had sent to council, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation. And if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So, all right. So we need a little time. I need to read those materials.
Sure. And,
Okay.
and for the court's edification, I don't anticipate, he's sort of towards the middle, I would say.
Okay. All
Wow.
right. Good. And the more fully the records developed, and the easier to rule on some of these motions. I just want to give you all some idea so you know how to prepare for the next 2 weeks. So,
No problem.
right.
Do what you got
so
to do.
not in your openings on either one of these, Ms. Gianetti, but you agree to that. So this is still under advisement. It may be
Okay.
certainly with
Fine,
Lank
no problem.
or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert. We'll see how the evidence develops, and I'll read more about the information that the Commonwealth was provided. So 318, also it's 28 bolded from the Commonwealth. All right, so Commonwealth's motion eliminate to admit, this is, you know what, I don't have a number on this one, Jim. Commonwealth's motion eliminate to admit results of
Go back to
defendant's
yesterday.
blood draw
and,
at Good
get my
Samaritan
email.
Hospital and resulting serum conversion and retrograde extrapolation.
Okay, but when this is over, I'll put my
All right,
email in
and
the
the Commonwealth, I mean, the defendants is 289. It's the addressing the same
description. Video.
issues. There, I told the
Email
Commonwealth to
me your
put this in
information.
writing.
I'll add
So
it to the
I
chat.
guess it's defendant's motion. So I'll hear from the defense. Your motion 289.
Thank you, Your Honor. With regard to that, we've put most of our argument in the paper, so I don't want to rehash all of those. The issue is really the foundational issue, not the extrapolation. The extrapolation is sort of a garbage in, garbage out argument, like computers. We think that the underlying blood draw did not follow the proper protocols that it should have followed. Therefore, the veracity of that particular blood draw is an issue.
All right, can I just ask, the Commonwealth intends to have witnesses here to testify to that, right? How the
Yes.
blood was drawn,
Yes,
all of
the
that?
Commonwealth would have the doctor that ordered the blood draw, the nurse / nurse practitioner. I summons both as far as who took the blood, and then the director of the lab at the Good Samaritan Medical Center. I
Okay.
hope to.
So let me get back to Mr. Jackson, and then I'll hear you on that. I just wanted that. I'm not sure we had all that information when you filed the
Okay,
motion,
but
but
do
does
I
that
need to
change
get
anything,
closer
Mr.
to the mic?
Jackson?
It
That may
doesn't
be the
because
problem.
the individuals that did the blood
Is that
draw,
better?
it wasn't done in an accredited manner. I'm not arguing with
Justin,
the fact that the blood draw was taken, that
obsessed.
somebody
I put my
phlebotomist
email
actually took
in
blood, but
the
it wasn't done with the protocols or the accreditation
description
that's required at the
of
Massachusetts
this
State Bar,
video.
Massachusetts State
Go
Police
look in
Crime
it.
Lab.
It's there. You
Their
can contact
protocols
me.
were,
Send me
I
your email
apologize,
so I can
their
add you to our
protocols were
chat.
breached internally. And given
Thank you.
that breach, we believe that any extrapolation based or founded upon those faulty blood draws, those unaccredited blood draws, are suspect as well. So the sum and substance is that you can't trust the extrapolation if it wasn't an accredited and a foundationally solid blood draw to begin with. which
So
is what-
if all the witnesses are here for cross-examination, why doesn't that go to the weight of the evidence instead of the admissibility?
Because we think that the admissibility is based on the protocols that the Massachusetts State Police have put in place. If they didn't have accreditation protocols, it wouldn't mean anything. It probably would go to the weight, not the admissibility. I think the admissibility is predicated on their own rules. They don't get, in our view, they don't get to break their own rules and then say, oh, well, let's just let it go to the weight, not the admissibility. We believe that it's important enough that it shouldn't ever come in front of the jury in the first place, notwithstanding the fact that we could obviously cross-examine them on the lack of accreditation. We think that it rises to the next level of not being trustworthy, and therefore
Okay,
it's overly
guys, I'm gonna
prejudicial.
be back in just a second.
Okay. Mr. Lally,
Never
doesn't
mind, he
this
got it.
happen in hospitals across Massachusetts on a regular basis?
It does. And just to be clear, nobody's breaking anybody's own rules. This wasn't blood work that was taken by anybody at the lab or tested at the lab. It was taken at the hospital, tested at the hospital. And what the technician or the forensic scientist from the Office of Alcohol Testing is doing is essentially mathematical calculations based on that result. So I would submit it goes exactly to the weight of the evidence. It's certainly fertile ground for cross-examination or argument by counsel. But as far as it being admissible, it's certainly admissible. This is what happens in every case. Whether or not Good Samaritan Medical Center's lab is ANAB accredited or anything of that nature is irrelevant. It has nothing to do with the state police strictures
Let me
because
get
they're not
off
the ones
the
who actually
mic.
conducted the testing of what was in the blood.
All right, do you want to respond?
I just wanted to refresh the court's
Ma'am?
recollection. I mentioned this at the last hearing,
Your
but just
heavy
one
breathing is
element
getting a little
of the
annoying
problem
and
is in the result. The
inappropriate.
extrapolated result was 124%
So,
swing. In other words,
off
we
the
extrapolated based on the blood draw.
Yeah, I know what
It
it means.
actually
And that's
hurts
just
my
massive.
ears.
I've never
I have
seen
those
any
inner
swing
ears.
that big. It's, you pull somebody over. Well, they have
Sounds like a
20.
great area for cross-examination.
I think it will be.
Okay.
But if it's not admissible in the first place because it's inherently untrustworthy, then you could save me my breath.
I don't see how this doesn't come in.
I'll submit, I don't want to beat a dead horse. I just think that it's so unreliable that it shouldn't be put before the jury. And we run the risk of prejudicing the jury in a way that we can't sort of unring that bell. Yes, we can
Can't
cross-examine,
get the crap
but
back
I
on the
don't think
horse.
that the underlying blood draw is foundationally solid enough.
Mr. Lally, were you planning on using this in your opening?
I don't have to.
All right, so why don't we wait and if need be, we'll have
I
the
feel
experts.
sorry for that court
Let's
reporter.
wait until it gets closer to these experts or
Three
the
sets of
folks from the
attorneys plus a
hospital
judge.
testifying. If we
We
need to have a
can.
short voir dire, you need to remind me to do that, Mr. Jackson.
Well,
Okay.
thank you for that, Your Honor. Appreciate
All
it.
right. Okay, so the last area I have is sort of logistics and sequestration. So let me, so the Commonwealth filed a motion initially. You know what, we'll hold off on the logistics regarding the audiovisual assistant. So there was a motion in limine for sequestration that I allowed regarding the family. So the victim's brother, Paul O'Keefe, the sister-in-law, Erin O'Keefe, the niece and nephew, can attend the trial after their testimony. So that motion 293 is allowed. I understand that perhaps, well, I was going to also allow Mr. O'Keefe's father, who appears for some reason on the defendant's witness list.
Oh, yeah.
He is
thank you.
exempt also by me from the sequestration order. All right, so that's John O'Keefe Sr. So I just added that in. So Mr. Clerk, 293 is allowed with the addition of Mr. O'Keefe
Thank you.
Sr. So the Commonwealth has filed a two-part motion, a motion for offer of proof regarding calling the elected sitting district attorney of Norfolk County and sequestration order if he is permitted to be called. This also includes Stephen Nelson, who is the victim witness person. So why don't I hear you, Mr. Lally or Ms. McLaughlin? I'll hear you on this motion.
This will be fun.
Yes, Your Honor. So the reason for this motion is, as the court noted, they appear on the defendant's witness list. Neither of them, I believe, has received a summons in regard to it. So there's no motion to quash because there's no summons to quash. But with respect to each, as the case law is abundantly clear, in order for these witnesses from a prosecution team to be subject to being called as witnesses by the defense, the Commonwealth is just seeking some sort of proffer whatsoever as to what areas they can testify to and only they can testify to. So if it's information that the defendant can elicit either through direct testimony or cross-examination from, and I would submit whatever, I would believe that whatever testimony they seek from either of these witnesses, they could get ample testimony from a multitude of other witnesses. Specifically, the only point that was raised as sidebar during impalement was with reference to the district attorney testifying as to whatever issues, purported issues of conflict or removal of Canton Police Department from the investigation. Certainly those are questions I think far more appropriate for members of both the Canton Police Department, members of the State Police CPAC Detective Unit. The head of that unit, Lieutenant Tully, is one of the Commonwealth's witnesses who will be testifying, and I think he's in a far better position to testify to that than Mr. Morrissey. But regardless of that, what the case law is very clear about is that, number one, the victim witness advocate is a part of the prosecution team, and in these sort of areas stands in sort of the same stead as a prosecutor himself.
I'll be right back,
Secondly,
Bill.
with respect to whatever areas of examination are expected or anticipated from these two witnesses, there has to be some sort of proffer of what that anticipated testimony would be that they can't get from some other witness. Certainly, Mr. Nelson has been the victim witness advocate working on this case.
So why don't you explain to me, I did look at the victim's Bill of Rights, but why don't you explain to me exactly what a victim witness advocate does, the nature of the relationship with the victim's family? I know there was a lot of discussion about this in grand jury minutes that I read about scheduling appointments, meeting with people, things of that nature.
So, I mean, what to say assist, I think is doing it somewhat of a disservice as far as the prosecution. It's someone who works directly with the prosecutor on virtually every step of the case, as far as investigation, as far as pending motions, as far as trial.
Has Mr. Nelson been the advocate throughout the pendency of this case?
Yes, Your Honor. So for over 2 years, has been the point of contact with the family, has been with the family at each of the court dates, is assistant and very helpful as far as coordinating things with the family, coordinating meetings, scheduling meetings with witnesses in preparation of grand jury, in preparation of trial, has communicated thoroughly with regard to issues of scheduling and all of those types of things.
Does he take calls like late at night from witnesses? Does he have a personal relationship with witnesses governed by a professional relationship? Is he somebody that they are able to call, there's been a lot of allegations of harassment of witnesses.
Correct.
Are those folks able to call him when something like that happens?
That is the person that they would call.
Okay.
Yes. So I think the bulk of the communications and conversations with witnesses who are not members of Mr. O'Keefe's family over the course of the last couple of years have been in relation to that issue specifically, as far as harassment, threats, intimidation, things of that nature, that he's dealt with admirably in relation to those witnesses.
Okay. All right. Who's arguing this for the defense?
I will, Your Honor, and I think it makes sense to separate out DA Morrissey and victim witness advocate Steve Nelson in
Okay.
this argument.
Let's start with Mr. Nelson.
Sure. Your Honor, the defense acknowledges that there are often times where, let's say, a victim witness advocate sits in on an interview with a witness or an alleged victim, but there are other witnesses in the room to whom or who could testify about the content of that, and that doesn't necessarily make it proper to call a victim witness advocate during a trial. I acknowledge that. I also acknowledge that the victim witness advocate has a job to do, and it puts them as sort of an intermediary between the prosecutors and the police and alleged victims.
So when you were prosecutor, you worked very closely with victim witness advocates.
I did.
Okay.
Yes, and it's my experience being on the other side that informs my knowledge of that. But this is a different case with regard to one specific issue. And that is that we learned as a result of the federal materials that victim witness advocate Steve Nelson had conversations with Brian Higgins and we believe Brian Albert, but Brian Higgins talked about him specifically. Mr. Higgins was asked, where is his cell phone? Why does he not have it? Are you aware of the preservation order that was issued by Judge Krupp in the Karen Reed case? And the answer came back that he was given permission to destroy or dispose of his cell phone from victim witness advocate Steve Nelson.
Did he say destroy? I'm trying to remember the
Well,
testimony. I don't think he said destroy.
I used the disjunctive rather than the conjunctive because from memory, I can't remember the precise language, but it was conveyed to, I'm told that the precise language was to get rid of, which, would be consistent with what I had
Told
said.
he could get rid of, not
Correct.
told he must get rid of.
Correct. In other words, Steve Nelson is overruling a colleague of yours, your predecessor on this case, who issued a preservation order which was never lifted. And yet he stepped into the case, gave authorization that he did not have to give for the disposal of a phone, which is relevant.
Okay, is that the sole issue you want to?
Yes,
The sole issue.
yes, that's with regard to Mr. Nelson. It's different with regard to Mr.
All right,
Morrison.
what's the Commonwealth's response to that?
I don't believe any of that is accurate. So what counsel is referring to is there was a motion to preserve cell phones. The Commonwealth notified each of the witnesses that were subject to the motions and the orders, sent copies of the motions and the orders, as well as a letter explaining that. There were conversations in regard to that. There was then a subsequent Rule 17 motion filed specifically for the physical phones. There were conversations with those specific witnesses, just advising them that the Rule 17 motion had been filed. They had to, hold on to their phones, things of that nature, explaining what the process was. The hearing was conducted, the Rule 17 motion was denied, and then those witnesses were subsequently informed that the motion had been denied. I believe even from Mr. Higgins' testimony in the federal grand jury the counsel is referring to, he was specifically asked whether or not he had been ever advised by Mr. Nelson, myself, or anyone from our office that he could or should get rid of his phone, and he said no. So I don't know what further needs to be explored on that particular point, as the question was, all of these issues were explored in that particular area. And just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know is not true.
All right, so Ms. Giannetti?
We believe that that's a misstatement of what was testified to. I think it probably makes sense for this court to look at his very testimony so that you can make a decision on this, Your
Yeah.
Honor.
So here's what I'm going to do. Let's wait and see. Let's wait and see how Mr. Higgins testifies. Okay. I am not going to order sequestration of Mr. Nelson, and let's see how the testimony is. And if you need to call him, you let me know, and we'll have another hearing on it.
Okay, what we'll do, and just to answer an anticipated question from the court, I do not open on this issue.
You cannot open on that issue, Mr. Yannetti. Do you
Understood.
still need the 45 minutes?
That takes away nothing from my
Yeah.
open.
All right. So Jim, I'll start writing. I'll write something on this.
Your Honor, with regard to the sequestration, I think it would be appropriate for the court to order that Mr. Nelson and Mr. Higgins not discuss this issue from here forward.
Are you willing to have that happen, Mr. Lally?
That's fine, Your Honor.
Yeah, I'd order it, but he's willing to do it.
Thank
so.
you.
All right. So I just need a minute to write this up.
Sure.
I don't know why it does this. I got to start double checking because when I tap one, they both go. Thank you, Sparkles. So the attorneys involved are, let me read that again. Where was it? Where was
All right. So regarding DA Morrissey.
Yes, well, thank you, Your Honor. So, Your Honor, the integrity of the investigation that was done in this case is certainly a live and important issue that is part of the defense in this case. I think the court would agree that we're entitled to question the integrity of the investigation, to attack it where we can. And it goes without saying that as the district attorney in Norfolk County, Michael Morrissey is in charge of that investigation. Now, in the usual case, that doesn't necessarily make a district attorney a witness. That would be unusual. There probably have been very few requests to have a district attorney testify in that regard.
Yeah.
However, this case is different for two reasons.
Being
One
federally
is the
investigated?
conflict of interest regarding the Canton Police Department, which Mr. Morrissey was involved in.
Okay.
The second is the manner in which he injected himself into this case personally and made representations that we should be allowed to challenge.
Do you
Fair
want to play that video?
We haven't made that decision yet. It may be that we elect to play portions of the video. It may be that we just elect to question DA Morrissey.
I have to think of other ways, right? That's part of the analysis that I have to follow in the law. So that's why I'm asking.
Of course. And I think before we get to that issue, Your Honor, the conflict issue is what puts him on the stand first. And we learned from the federal materials that former Chief Kenneth Berkowitz notified DA Morrissey at a very, very early juncture at 8:30 a.m. A phone call from Chief Berkowitz to DA Morrissey notified him that, Kevin Albert is on their force. He's the brother of the homeowner whose lawn contained the lifeless body of John O'Keefe, and that DA Morrissey was involved in that decision. He received the information from former Chief Berkowitz and concurred that the Canton police were conflicted out. And then the problem is that the Canton police they had their hands in this investigation, including that day after 8:30 a.m. and going forward. And there were, updates that were provided to Kevin Albert by a trooper under DA Morrissey's control, that, there were violations of that sort of conflict of interest taking Canton out of the case that DA Morrissey became aware of and that DA Morrissey did nothing about. And so in terms of, us being able to, attack, question the integrity of the investigation.
Why can't you do it through other witnesses?
We can, but the buck stops with
With
District
him.
Attorney Michael Morrissey.
Yep.
He was the one that was involved at a very early juncture on this precise issue of the conflict.
He involved
And he
himself.
became aware that that conflict was violated time and time and time again, and he did nothing. And I believe that that's ripe for cross-examination. And, with regard to his statement to the press, this may even be more compelling, not because of the bias necessarily that he showed. That's not the strongest part. I think it is strong, but it's not the strongest part of his statement. His statement makes factual assertions, some of which we heard for the first time. In that videotape statement, he announced to everyone, including potential jurors, that Trooper Proctor never reported to the scene on January 29th. That's in direct conflict to police reports that we received
Interesting.
from the troopers saying that they reported to the scene. And we would argue, trying to use semantics to get out of that, and now saying that for the first time in my career, I've heard that the crime scene is actually the police station that's across town. That doesn't make any sense. It doesn't pass the straight face test. But those are his own words. And he made himself a witness by uttering those words. And he also talked about his view of what witnesses did or didn't do and whether they're suspects or not suspects. Again, he injected himself into this case. He
Sounds
made
like it.
himself a witness. And there's really nobody else we can question about his knowledge that he had when he made those statements and why he made those statements. And also the fact that, he was involved in this conflict decision from the beginning. So that's our offer of proof.
Mr. Lally?
I mean, as far as his statements, his opinions are completely irrelevant. And I think what counsel is referring to as proper for cross-examination, they might be. But this would be a witness that they're calling themselves. So for direct examination of your own witness, I think it's improper, number one. Number two, there is ample other avenues to explore this through other witnesses, which counsel can certainly do. You
don't want your district attorney getting
related
up
to
there looking like a
whatever-
freaking
As the
idiot.
law tells me I have to consider.
Correct. And so, as it pertains to whatever extent the court allows, as far as the Bowdoin defense is concerned, then I think it's fertile ground for cross-examination of other witnesses in respect to that. But as to whatever statements were made or not made by something that someone doesn't have recipient knowledge of, because I don't think anybody's saying that Mr. Morrissey was at 34 Fairview Road. So with all of those things in consideration, I don't think that it's even close to a valid proffer as to why the district attorney or Mr. Nelson need to testify on their own as to any of those things. The last thing I would just note is with respect to Mr. Nelson, the alleged mischaracterization that I made in regard to Mr. Higgins' testimony is actually contained on page 140 of his testimony.
140.
140.
Could you read it? Do you have it there? If you don't have it there.
It's more so I don't know that I'm
Okay.
ready to.
Okay.
Your Honor, if I could just add one thing that I should have mentioned, which is on this issue of whether there's another issue, another witness that could testify.
Yes,
Which
because you did say, yes, we can get it in through other witnesses.
Yes, except the one thing we can't get in through other witnesses potentially is the phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only 2 people on that call, and the Commonwealth is seeking to take Chief Berkowitz off the witness stand as well.
Are you? I didn't see anything like that.
No, I'm not seeking to keep him off the witness stand. What I informed counsel is as to his current medical condition, and informed counsel that's why I didn't summons him. But I'm not
Oh,
seeking
I
to
knew nothing about this.
prohibit
Okay,
him
yeah.
from testifying.
My understanding was that the prosecution didn't believe that he would be able to testify.
This is the first time hearing any of that. All right. So it is a stretch. It is an uphill battle for you,
Mhm.
Ms. Giannetti. I will allow you to revisit the ADA Morrissey at the close of the Commonwealth's case. Right now, that your offer of proof is not enough. I'll give you the opportunity to do it again based on the testimony that comes in. And I am not excusing him, or he is not subject to the sequestration order.
Understood, Your Honor. Thank you.
All right. So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards.
Great, thank you.
All right. So when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday or the Friday
Mhm.
before. I ended that with saying twice, is there anything else we need to discuss regarding housekeeping or logistics?
No, Your Honor. Now
And
there's
I
a
was
bucket
told
load.
no by both parties. And then I get a motion the following April 19th, the end of last week, about wanting to use not just having an a technology audio visual assistant at council table, but to use, it's much more extensive than what I expected. The Commonwealth filed their motion and it was allowed previously because it happens in every single case in these courtrooms, and the Commonwealth shares their equipment. Please tell me exactly what it is you want to do. And I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Ms. Giannetti, talking to your client. So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So tell me, are there any agreements of counsel? Is there any, I know nothing about this, and I asked for information previously, so I could have thought
Somebody did a
about it
no-no.
and, you know, seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this.
But you didn't
accommodation.
do it in writing, and you didn't give me specifics.
Your Honor, we asked you and you then said, put it in writing. Then we put it in writing. And we
But
did
the first
exactly-
time it was brought up was after I had asked about logistics.
We don't
Go ahead,
want
tell me exactly what it is you want to do.
Okay, so it's a very modest request. Under ordinary circumstances, and we've utilized his services before, he would sit at counsel table and he would run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court reporter, for opposing counsel.
But he
can
cannot
put
talk to the
monitors
witness.
at the request of the court.
I mean,
Put monitors on the
the
bench,
defendant.
a monitor in front of the court reporter, a monitor in front of the Commonwealth, and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of.
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean, we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for us if I'm up on a cross-examination or Mr. Yannetti is up on a cross-examination, and we say, okay, if let's say we've got internal
They're
bait
trying to get a
stamps that
person to
show
sit at the
number
table that
photograph number
normally does
231,
not sit
he'll
at
know
the
what
table.
photograph number 231 is. He'll have an outline that tracks our cross-examination or a direct examination.
So it will be only things that are in evidence or will be coming into evidence. You're not going to do that with disputed.
Absolutely not. We would never do that. If there's anything that's disputed or even remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. No, all it is just a sort of a facile accommodation of seamlessly showing multimedia or playing an audio or playing a video for the jurors.
He's trying hard.
All right. What's the Commonwealth's position on this?
Nope.
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever assisting with the trial. If that's what it's limited to, I don't know. About the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as equipment or screens or whatever is obviously fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. There are the jury
Yes.
seats. They're for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the
Correct.
judges. So
Just like
the
we
bottom line is,
saw
if
in
we had known about
the-
this 2 months ago, we would have been able to really put the time into seeing exactly how this works. Ms. Tinetti, I'd like to finish first, and I'll give you the
George Kelly
opportunity to speak
trial.
to
That was
Mr.
flawless.
Jackson, to really see how this works, see how we set it up. I can't devote that time to it right now. No monitors, I don't want a monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that very small courtroom now at your request. So we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's
Yeah,
concern. This is extremely modest, and it's not going to take a whole lot of presentation. If the court doesn't want to monitor, the court says, I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then the court can say, I don't want monitors that close to the jury. Then what I would do is just use paper copies. When I'm up on direct or cross-examination,
This should have been
I
dealt
don't
with
want to
a
have
long
I can't
freaking time
prepare
ago.
with the Commonwealth's.
I understand.
No,
your
I
frustration.
understand that.
Wow.
I don't think he'll fit at council table.
I can't speak to that. I think he would. I think we can accommodate him. Or if he doesn't fit right at council table, we
I would
also
adjourn
set
this and
up-
go look.
He was on.
Have you not
a
looked?
relatively large case that we had in a small.
Did you not
place
look
back in
before coming
California.
in and presenting
Just
this?
behind council table, and he's got his own laptop, and nobody else can see it. And he's got a type of screen that you can't see it from angles, so jurors are not going to be seeing anything. But I need to be able to, and Ms. Little and Mr. Yannetti need to be able to prepare with him. And I think the court.
No, I understand that. I don't have a problem with that. It's
Wow.
the 4 monitors on the tables, one on the bench,
then-
one for the
then
court.
we won't,
We're in a small room.
then we won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's, again, a tiny room at your request.
He uses very modest speakers that are appropriate for the space. So for instance, in this space, it would be probably a couple of speakers that are larger so that the jurors can hear and the court can
Wow,
hear. In
yeah.
a small space, he'll just pare it down and use small speakers. And there's a switch. So for instance, he will work with Commonwealth's AV expert, and there's a switch on both tables. When it's my turn, switch. And now
All right,
he's
so
pulled
so
the
is
others.
that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with. I mean, we just got Wi-Fi in this building a week
Oh,
ago. I mean,
snap.
it's
Are you
not a
kidding me?
building that,
I understand.
we can just last minute. It's a beautiful old historic building. We want to keep it that way. So,
And we will not mess anything up. As a matter of fact, I was told that by the
OMG, you're
Commonwealth
telling
that
me
she uses switches,
that in this
consistently.
day and
That's
age,
not new technology. It's
you
very simple.
just
It
got
just allows
Wi-Fi
both
in
of
that
us
court?
to be able to prepare with the audio-visual portion of the
Oh.
case more seamlessly. That's all.
Now
We
it's
just want to make it
just overwhelmed
more
that she's not
seamless
used
and
to
more
dealing
professional
with
for
any
the
of
court
this.
and for the jurors. That's
so it
Snap.
would be during your case in chief.
it would be during my cross-examination of every one of the witnesses. I mean, the
It's
bulk of
really
the
not
case is
this
going to be
big
the
of a deal,
Commonwealth's case in
y'all.
chief.
Your
All
Honor,
right, with exhibits that are already into evidence, you're not trying to enter exhibits during
Your Honor.
cross-examination?
I mean, unless it's an
go
impeachment
look at the
that
George
I didn't
Kelly
see coming.
trial. This
But
is
even
how
in
they
that
did it.
case, my
Getting
habit
it
and practice, my custom and
flawlessly.
practice would be to approach if it's a matter in controversy or tell the Commonwealth in advance, I'm about to show this photograph. Do you have
Oh,
the issue with
Lord,
it? No,
my,
I
my,
don't.
my.
And then we'll show it. But I would never, the point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be shown
He
seamless and
just
more
wants
professional looking.
a monitor for the jury, a monitor for the judge, and a court reporter, and one for him
Does the
and the defense.
Commonwealth and Ms. Gilman have
And
an
everything gets put
opportunity
up on the
to
monitors
spend a little
so
time
everybody
today
can
to
see.
take a look at
And
it?
if the jury doesn't
See,
supposed
I
to
mean,
see,
everybody's
the jury's
preparing for
monitor
trial,
will remain
obviously.
black.
Again, this
The
is,
guy's going to have a switchboard.
I
We'll
don't
be
have the
able to
time to
control
do it. And I understand if you don't, but
I think Ms. Hillman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told he was going to be here. So, but
Well-
I'm happy to have Ms. Gilman.
Ms. Gilman, are you willing to spend some time today? Thank
You're
you.
going to have to.
By the way, just Mr.
Mhm.
Bates's defense,
What they're going
Yes,
to
he
do
was
is not
supposed to
going to
come last
affect the
Friday. He was
beautification
told he couldn't
or
come because
destroy
he
the
had not
beautification of that building.
Okay.
We did
All these
not-
Well,
wires
that
are
makes
non-
sense, frankly.
I just didn't want there to be a sort of a hanging Chad where that's concerned.
Mm.
He didn't leave.
Well,
it.
especially where he didn't start out well, right? Being at council table during impanelment.
I understand that. And he's been told that that was inappropriate and obviously would never happen again.
Okay.
All right, so some sort of ground rules. Only one
Will
counsel,
give me a headache.
whoever's doing the cross-examination of the witness objects. Just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission. At sidebar, there will only be one person talking again, and it'll follow with whoever does the examination.
So not
Many
every
times
legal
I allow
representation
counsel
comes
to
up on
discuss
sidebar,
things,
just the ones involved in
and
the
many
examination.
times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object.
No
That's it.
talking
And
objection.
if we need to see you at sidebar, we'll see you at sidebar. But I don't want a whole litany of reasons why the testimony
In other
you
words,
think is
objection
inadmissible.
leading,
So those are pretty standard rules.
not objection
I'd
leading,
like
Your
to
Honor.
see
He's
counsel at
asking.
sidebar regarding a
do
jury
that.
issue.
Done. She's like, snap it out of here. Oh, Lord have mercy, y'all. Y'all. Oh, come, please now. Now what's happening? Wow. Okay, y'all. That was quite interesting. Why did they bring up all this technology today when they're going to trial Monday? And I guess there's going to be a live tomorrow. Now, tomorrow I will not be on because I'll be driving to pick up my daughter for college for the weekend. So let me skim forward and see if they come back. Look at the courtroom. That's pretty full. And everybody's wearing pink in support of Karen Reed. So the pink is in support of. Those are supporters. That will not be allowed for the day of trial. The court has not been adjourned. They are still all setting. Let me skim forward. They're meeting at sidebar. We're still live. It ended 20 minutes ago. Okay. So that's done, y'all. Done. What do you think? Oh my Lord, y'all. Okay. So now what we're going to do is if I can get this to work appropriately, let's do that. Maybe not. That's not what I wanted to do. Nope. Okay, I'm going to minimize the comments here. Minimize. Bring this over here. That works. Okay, so one of the things I wanted to do is because I'm coming into this trial fresh, I don't know the players. I don't know who is who. I don't know what is what. So let's talk about the law team for Miss Karen Reed. Who I want to see who is. Okay, so this is pretty interesting. Right now it says right here. Okay, so Alan Jackson is in parentheses called Proudly Relentless. California lawyer who joined the Reed's defense team in last September. Jackson often appeared at ease with the media. Attending to her case has attracted a skilled, likely honored over career path trying to high profile cases. Okay. As a prosecutor in Los Angeles, he secured a murder conviction against a music producer, Phil Spector, in 2009. Hold on. Okay, give her my contacts. So he is one of the attorneys. And he quotes, "Once I heard the full story of John's death and saw some of the evidence, including the injuries to his arm, I knew something was terribly wrong. I wanted to help. I got into this business to right wrongs, and there is no way I was going to walk away from this case." He said he approaches every case with the same vigor in pursuit of the truth. The justice system is a system built for everyone, rich or poor, famous or anonymous. It doesn't matter. We are all entitled to a zealous defense, Jackson said. Karen's case resonates with me because of the travesty of justice that has befallen her can happen to any one of us. So, David Yannetti, they're calling him the fearless litigator. Yannetti has been on Reed's team from the start, bringing with him decades of experience in the Massachusetts courts. He did not respond to an interview request. Okay, so they wanted to interview him. He made a name for himself as an assistant district attorney and the senior trial prosecutor in the Middlesex County, and I have to grab that. So what I'm going to do is, I hate to do this mods. Let's keep it going. I'll throw some music on. I'll be right with y'all. Okay. I'll be right back. guys for holding. I explained earlier that I have a puppers who is not well, and so have to go and, you know, yeah, she's not feeling well. My service dog is an angel to me, and I love her to death, but she's not feeling very well. She's had a cold and it's just feeling crappy. So Mr. Yannetti is another high-end attorney. Um, so that's the main of her team. Then I told y'all that we would go through the biggest thing is what we would do is go through the entire playlist. So let's do that. Now, I do have a hard stop today at 3:00 my time. I have another, what's the word I'm looking for? An Zoom call that I have to participate in. I want to. So let's start off with Miss Karen Reed herself. She is a 44-year-old Mansfield woman accused of um, backing her SUV onto her boyfriend, Boston police officer John O'Keefe, and leaving him to die outside of the home in Canton, January 29th, 2022, following a night of drinking. Reed has pled not guilty to the charge of second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a crime. I think I'm gonna use this one. I like it better. Sometimes we like things better. Um, Karen Reed and John O'Keefe were in company of numerous people on January 28th and 29 when a night of bar hopping ended with the discovery of O'Keefe's body in the lawn of Boston police officer's home. What each of those people told investigators became even more closely scrutinized when Reed's lawyer began accusing them of participating in a plot to frame her for the boyfriend's death. He looked at who's who in okay, here's a look at the who's who. Okay. Uh okay. John O'Keefe. John O'Keefe's friends and relatives described the 46-year-old victim as a loving uncle, loyal to and generous friend, and dedicated police officer. Do that so I can see better. They expressed fear that the tragedy of his death has been forgotten amidst the circus atmosphere of this trial. Born and raised in Braintree, O'Keefe earned a master's degree in criminal justice from the University of Massachusetts. He was an auxiliary police officer in Duxbury and Falmouth before joining the Boston Police Department at 29. According to the Globe, he was assigned to station in Hyde Park or downtown and Dorchester and worked in the, I'm going to say it here, I might get banned, sex offender unit during his 15 plus years in the department. O'Keefe reportedly switched. Would it be better for me to read? Yeah, I have bifocals, y'all. That's why I'm showing you my nose. O'Keefe reportedly switched to administrative role when he became the legal guardian of his niece and nephew after the sister's death. Let's stop there. I found out that the sister died, and then later the husband, the brother-in-law, died. They did not die together in a car wreck. O'Keefe and Reed had been dating for 2 years when O'Keefe died. The couple did not live together, but Reed spent most of her nights at O'Keefe's Canyon home, where he lived with the niece and nephew. The teens provided firsthand accounts to the investigator the couple's allegedly deteriorating relationship. They were not the only ones to do so. All right, Karen Reed, we talked. She's the murder suspect. She worked in a finance and was at one point served as an adjunct financial investor at Bentley University in Waltham, Massachusetts. Reed told ABC Nightline that she and O'Keefe dated in their 20s and then reconnected on Facebook during the time of the pandemic. She had become a part of the O'Keefe family, helping care for the niece and nephew. Over time, Reed said that O'Keefe became critical of her childcare decisions and it strained the relationship. Now, by the way, why in Sam blasted blickety bleak 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 would you sit there and go on a freaking live TV show with attorneys also when you're charged for the crime? I never understood that. Reed and O'Keefe joined the Alberts, husband and wife, and McCabe's and their friends at a Waterfall Bar and Grill in downtown Canton on the night of January 28, 22. The witness at the bar said that Reed complained about O'Keefe's mother and the lack of private time the couple had for vacation, partly because O'Keefe's children. So she was getting a little bit girlfriend jealous of children time. Reed told investigators that she left O'Keefe and Albert at the Albert's residence after fighting with him in the car over the child care. She drove back to O'Keefe's home and woke up the next morning in a panic because he wasn't there. Reed used the O'Keefe's niece's phone to call Jennifer McCabe and Carrie Roberts. The two women drove with her to Albert's residence at 34 Fairfield Road, where they came upon O'Keefe's bruised and frozen body on the lawn. Well, I have a question. If you're worried about your boyfriend, why are you calling two women, Jennifer McCabe and Carrie Roberts, to go with you? That that doesn't make sense to me. I'd just hop in the car and go. Brian Albert, owner of the Canton home where the O'Keefe body was found, is a police officer and a lifelong Canton resident. Brian Albert said O'Keefe never entered his Fairview Road home the night in question, so he was not in the home that night. Albert and his wife, Nicole, met family and friends at the Waterford Bar and Grill downtown Canton the same night of January 28th of 22. Albert invited everyone to their house when the bar closed around midnight. The Alberts said they did not know Reed and had only met O'Keefe a handful of times, but they were welcome all the same. The Alberts said they learned of O'Keefe's death the morning from Jennifer McCabe and Nicole Albert's sister. Reed defends claim early morning phone call between Brian Albert and his friend, Brian Higgins. God, there's too many Alberts and Higgins. Suggests something was amiss long before O'Keefe's body was found. This was like 2-something in the morning. These calls happened. Through his lawyer, Alberts has declined that he was involved in O'Keefe's death or the plot from Reed to frame Reed. Nicole Albert, wife of Brian Albert. Nicole Albert said she arrived at the Waterford Bar and Grill at 7:30 for dinner with family. Her husband, Brian, arrived around 10. Albert said she had never met Reed before that night in question and only knew O'Keefe as the uncles of her niece's friend. Albert said he did not know that her sister, Jennifer McCabe, invited Reed and O'Keefe to her house, but they never showed up. Everyone left the Alberts' home about 1 a.m. Albert said she learned that O'Keefe's death the next morning when her sister came into her bedroom and informed her and her husband. Wow. Everyone left the I'm sorry. The defense claimed the cell phone data suggests McCabe called her sister within minutes of discovering O'Keefe's body and calling 911. Kevin Albert is the brother to Brian Albert, the Canton police officer where this happened in the home. Are y'all following me here? Y'all. So Kevin Albert is one of Brian Albert's 6 brothers. Oh, geez. According to Reed's defense, Kevin Albert tried to act as an intermediary for his brother and his brother's friends, Brian Higgins, after federal grand jury subpoena went out. Why? What's beeping on my computer? Why? That doesn't make sense. Why would you get involved? Kevin called Higgins after Higgins stopped returning Brian's calls and texts. Quote, "There's only one way to interrupt that. Brian Albert was concerned that Brian Higgins had flipped on him," Reed lawyer David Yannetti said in a hearing. Kevin Albert's lawyer described him as a respected 19.5-year veteran of the Canton Police Department. Quote, "Any institution that he's participated in conspiracy is untrue." Okay. Sparkles, when y'all said this has got more rabbit trails, yeesh. Jennifer McCabe, sister-in-law to Brian Albert, the wife of Matthew McCabe. Jennifer McCabe said she knew John O'Keefe through her daughter, who was friends with the O'Keefe's niece. McCabe came to know Reed through O'Keefe. McCabe and her husband Matthew said they arrived at the Waterfront Bar and Grill around 9 p.m. after attending a high school basketball game. The McCabes were among those who went from the bar to the after party at the house. Jennifer McCabe invited the O'Keefe and Reed to the after party, texting O'Keefe the address and where to park. McCabe and her husband said that they saw Reed's car arrive at the Alberts' residence, then leave. She said she did not see Reed or O'Keefe exit the car or enter the home. Hold on a second. I hate to do it. I'll be right back. Okay, y'all, I'm back. My poor puppers. Come here so y'all can see puppers. Up, up. You want to come up? No, she doesn't want to up. My puppers is not feeling well, and I'm having to attend to her and do this at the same time. Prayer for my puppers. She's my service dog. This is the first time she's ever been sick. I think it's allergies or a bad cold, but got a runny and making her nauseated. So let's get back into it. Jennifer McCabe and her husband said they arrived. Okay, McCabe and her husband said they saw Reed's car arrive. McCabe said that she and her husband left the Alberts residence about 1:30 a.m. and gave rides home to 2 friends of Brian Albert Jr. Reed's defense claims an analysis of McCabe's cell phone suggests she left over closer to 1:47. You know what? When you're drunk and partying, that's close enough for me. I mean, and passed O'Keefe's home on her way home around 4:53 a.m. Reed called McCabe from O'Keefe's niece's phone looking for O'Keefe. Reed and McCabe drove with Reed's friend Carrie Roberts to Albert Roberts' home. They arrived at 6 a.m. That's an hour. To find O'Keefe's body in the snow. After discovering the body, McCabe said that she and Reed prayed the Our Father together inside the car. What? Was that before or after you called the police? Thank you, Sparkles. Was that before or after you called the Who stops and prays the Our Father in the car when they see a dead body sitting there or body laying there? You go and see if they're still alive and you call 911. And I've been on many of these scenes. So y'all, this to me is a little fishy. McCabe said Reed asked her to Google something to the effect of how long do you have to live outside to die from hypothermia? What? Reed's defense, however, claims McCabe's cell phone data suggests that this search occurred at 2:27 a.m. Oh. Okay, a lot of people saying she's innocent. Why are they texting this at 2:27 a.m.? Reed's defense claimed that McCabe tried to delete the Google search along with the calls and texts with Brian Albert that may point to a cover-up. The timing of the Google search is a key point of contention in this case. The Commonwealth claimed that Reed's cell phone expert misinterpreted the data. Yeah, we'll see. Chris Albert is brother to Brian Albert, husband to Julie Albert, father to Colin Albert. Are y'all following? In a minute, I'm going to throw up No, I might be able to do it while we're doing this. Give me a moment. I've got to find a way to open these up. Give me a moment. Just open as a photo. Can I share this? Let me see if I can share this. I'm going to open multiple things up. Y'all give me a quick moment. Open as a photo. Thank you. And this one. Open as a photo. Oh, that's not a very good copy of it, but okay. And I'm going to expand this one if I can. That's not. By the way, y'all, I do have permission to show these. By the way, and I'm trying to do them in order because what I want to do is show you guys these photos to help you guys understand. Now, these were given to me, permitted for me to use. Oh, it's not showing up. Dagnabbit. Window. I can show them as windows. Share. I'm going to take my picture out of this and let y'all look at this as a whole. Okay, so if we're looking on this main screen, thank you so much, Brandy in Church. She's the one who created this, and she gave me permission to use these. Okay, y'all. So here is the path of people. Down here where you see my mouse wiggling is John O'Keefe and Karen O'Keefe. We are now discussing Chris Albert, Brian Albert's here. He's married to Nicole. They're the owners of the home. You can see my cursor. Chris Albert is to his left, our left, right here, who's married to Julie Albert. Colin Albert is, I guess, the father. Okay, so Chris Albert, brother to Brian Albert, husband to Julie, and father of Colin. Okay, so we got that up. So let me throw myself back in there. Let me get them both open and going so it makes it easier. How about if I did that? Okay. Get rid of that. Okay, I know I'm in the bottom, but that's okay. I want you to see the screen. So this is who we're talking about right here. Chris Albert. Okay, one of Brian Albert's 6 siblings, Chris Albert's wife, Julie Albert, here she is, have made conflicting statements about whether they attended the after party. Reed's defense claimed that Chris and Julie were part of the meeting at Fairview Road residence where there was a cover-up beginning the morning O'Keefe's body was found. Reed defense portrays Chris as a direct link to the lead investigator, Michael Proctor's family. Okay. Michael Proctor, right up here in gold. I lost my place. I got to find my place again. Portray direct lead investigator. Okay, there it is. Chris and his wife, Julie, that's right over here where my cursor is, were at the Waterfall Bar and Grill. He told investigators they followed Brian Albert to his home, but it is not clear if they went inside. He told the grand jury they went home without attending the party. So now they're saying they followed Mr. Albert to his home, but did not go in. Reed's defense says Facebook photos depicting the Alberts and relatives of Proctor's are evidence of close potential ties between Proctor and the Alberts. Proctor. Alberts. Proctor is a lead PD, a state PD lead investigator. Defense filing includes images describing as photos of Proctor's sister's Facebook profile dated July 25th of 2016 shows Chris Albert, his son, Colin, with a group of adults and children identified as Proctor's mother and his sister. Prosecutors say that the couples have suffered threats and harassment because the defense claims Chris Albert owns a pizza shop that has been a target of demonstration and bogus orders. So, wow. Okay. It gets deep, y'all. Julie, I'm going to bring this. I want to bring this over here, but then I can't see that. Julie Albert, sister-in-law, right here, to Chris Albert. All right, sorry. Julie Albert, sister-in-law of Brian Albert, wife of Chris Albert, and mother of Collins. You're seeing my mouse go. Reed's defense portrays Julie Albert as a key link between the Alberts and the family of the lead investigator, Michael Proctor, over here. Julie attended the wedding of Proctor's sister and cared for her children. Like her husband, Julie was at the Waterford Bar and Grill on the 28th of January 22. She said she followed her brother-in-law to his home, but it is not clear whether she entered the house. She later told the grand jury she went home from the bar, did not attend the after party. Julie told the grand jury she first learned of O'Keefe's death when she went to Albert's home the next morning to drop off a birthday cake for her nephew, Colin Albert. Brian Albert Jr. Nephew Brian Albert Jr. Sorry. She told investigators she learned about his death after missing a call about 5 a.m. from Jennifer McCabe. In the pre-trial hearing, Reed's lawyer, Alan Jackson, said federal investigations learned 2 days after O'Keefe's death that Trooper Proctor's sister sent him a text concerning Julie Albert's quote, "Just saw Julie, and Julie said when all of this is over, she wants to give you, Michael Proctor, a thank you gift." Y'all. Jackson said, summarizing the text, sorry. In another partial text or purported text with family members 10 days before the O'Keefe's death, Jackson said Trooper Proctor discussed the specifics, in quote, of having Julie babysit his toddler's child. Prosecutor Adam Lilly acknowledged the relationship between Proctor's sister and Julie Alberts and offered an explanation. Quote, Julia Albert had provided child care in a pinch on several occasions for Trooper Proctor's sister, Lilly stated. Prosecutors said Julie has also endured threats and harassment because of the defense's claims. Oh my gosh, how long does this go on, y'all? Holy Moses. Holy Moses. Sparkles, thank you for hanging in there. Brian Higgins, close friends. Let's find Brian Higgins. We've got too many people on these charts. Brian Albert, Brendan Albert, Tristan. Okay, it's on the next chart. Okay. So let's see if I can find him because of the picture. Okay, Brian Higgins down here. Okay. Brian Higgins, closest friends with Brian Albert, in a romantic connection with Reed. Oh, shade. Are you telling me that is? Oh, so Reed was having an affair with a coworker while she's dating O'Keefe. Oh, y'all, this is soap opera. All right, my cursor's on Brian Higgins right here. Higgins is an agent with the Federal Bureau of Alcohol, Tobacco, Firearms who has an office in Canton Police Department. ATF? What? Higgins was at the Waterfall Bar in Albert's home for the after party that night in question. Oh my gosh. So maybe, oh my gosh, the plot thickens. 2 weeks before O'Keefe's death, Higgins said Reed unexpectedly kissed him. Oh, Reed, you dirty girl, you hussy. Oh, Lord have mercy. So Higgins said Reed unexpectedly mwah, kissed him on the lips while Higgins was at O'Keefe's house to watch a football game. In the same house with O'Keefe? Oh, woman, you've got some cojones. Higgins and Reed began exchanging texts expressing mutual likings for each other, with Reed inviting Higgins over to her house at least once. Oh, oh no. Oh, wow. No problems. Leave if you have to. No big deal, babe. I got you. I appreciate you hanging. I'll try and get this tidied up because I got to be on a Zoom call at 3. Oh, hold on a second. It is not clear if Higgins interacted with Reed when the two were both at the Waterfall Bar and Grill. Reed's defense said that Higgins initially told investigators he did not speak to anyone the morning after he left the party, but the federal probe of the Reed's case suggests otherwise. Oh my Lord. Are you kidding me? So Brian Higgins, I'm circling here, and my face is in the way, so I'm just going to get me out of there. How about if I just get me off of this? Okay, I'm off. OMG. So you have Karen Reed, who's in a committed relationship with John O'Keefe, who is starting a relationship with Brian Higgins, committing an adultery on OMG. And Brian Higgins is in alcohol, tobacco, and firearms, and he denies having any, just that one, denies having any kind of um communications, but they're, oh wow. Now let's move on. We're still here on Brian Higgins. Reed's defense says Brian Albert called Higgins at 2 a.m. and Higgins called him back, but the two did not speak. Both men said these were butt dials that they placed from their respective beds. Okay, here's the butt dials. Oh, snap it. Okay. Higgins, down here, also said he ignored a call from former Canton Police Chief Berkowitz over here that morning and later found out about O'Keefe's death. From Albert. Okay. Julie Nigel is not in a picture, but there's a square. Friend of Brian Albert. Julie Nagel, was at the Albert residence before Brian Albert Jr.'s birthday party. Nagel, I guess, called her brother to request a ride home and decided to stay longer. Oh, yeah, that's the 2 butt dials. Nagel said she left the McCabe's around 1:30 a.m. Okay, now we're going to Brian Nagel, sorry. The brother, and I don't see him listed on this. I'm looking on the chart. Anybody see Brian Nagel? Nagel? Nagel. Nagel. Let me see if he's on the other. Nope. Let me see if he's on the other. Ryan Nagel, right here. Okay. But y'all can't see that. I'm going to share this window. Stop sharing. I'm going to add this window in. Please give me a split second. It takes a second to do it. Share screen. Share window. I am on this one. Share. Okay. It's down here. It's kind of hard to read, but this is where, so Brian Albert, friends with Sarah, Julie, and Ryan. Ryan Nagel said his sister called him that night in question, asking for a ride home from the Alberts residence. A friend drove Nagel to Fairview Road. They pulled up in front of the house at the same time as a mid-sized black SUV resembling Reed's. He declined his sister's invitation to join the party and left. As he drove away, Nagel, that's probably what it is, Nagel or Nagal, said he looked inside the SUV and saw a white woman alone in the driver's seat. He also told police he didn't hear or see any activity suggesting people were arguing in the SUV. Okay, now I'm going to go back to this other screen. And we're going to share this window going back to here. Okay. Michael Proctor, right here in the yellow. Lead investigator. So the lead investigator has connections and family, friends to the victim, and all in play. Massachusetts State Police Trooper Michael Proctor his partner arrived at the Albert home the morning of January 29th, a few hours after Canton police. They took over the investigation because the homicide case are typically the jurisdiction of the state police, and because of the conflict of interest between Brian Albert and his brothers at Canton police as police detectives. Well, but you two have a connection. So why are you investigating? Y'all tell me if I'm wrong on that. I'm a little confused. Reed's defense says conflict of interest exists among Proctor and the McCabe's and the Alberts because of the close personal relationships among the 3 families, a conflict that created the debilitating bias against Reed in the investigation. The Commonwealth calls the relationship tenuous at best, saying Proctor is a few people removed from any direct contact with Brian Albert and the McCabe's. Okay, just let me see this because I have moved this a little bit. Yeah, he handles a lot of evidence. It is a conflict of interest. Reed's defense points to Facebook photos to support their conflict of interest and claims. One photo is described as showing Chris Albert and Chris's son, Colin Albert, with Proctor's sister and mother at a social gathering with other children and adults. Another photo at a wedding, and I'm seeing this photo, shows young Colin Albert and Proctor in photo with Proctor's sister as the bride. Proctor's family lawyer laid out the degrees of speculation in the wedding photo. Brian Albert's sister-in-law, Julie Albert, Chris's wife, was friendly with Proctor's sister. Proctor's sister invited Julie as her young son to the wedding. Jeez. Holy crap, we're losing it. Including being alone in the car after it was seized in the piece. Oh, you're getting ahead. Oh my gosh. Elizabeth Proctor, wife of Michael Proctor. Reed's defense tried unsuccessfully to obtain cell phone records from Trooper Michael Proctor's wife, Elizabeth, after Reed's supporters posted photos on social media showing Jennifer McCabe's car outside Proctor's home September 2023. Oh boy. The Commonwealth said that the women met to commiserate over the threats and harassment they've endured because of their connection to the case. Proctor's also said Trooper Proctor was not home when the women met. Now we are on Colin Albert, nephew to Brian Albert, the son of Chris Albert and Julie Albert. Colin was about 17 when O'Keefe died. According to the Commonwealth, Colin left his uncle. Oh, geez, sorry. Uncle's home shortly before the group arrived in the bar. Albert was at the house of celebrating his cousin Brian Albert Jr.'s birthday. The defense motion claims he was left the house about 12:30. In addition to the July 16 Facebook post, the defendants points to another one in May 16 of 2012 of a wedding party, evidence of a relationship between the Proctors and the Alberts. The photo allegedly shows Proctor's sister as the bride, Proctor himself, and Colin Albert as a young boy. The Proctor family lawyer laid out the connections in the wedding photo. Colin's aunt, Julie Albert's sister, were friendly because of Proctor's sister, and Proctor's sister invited Julie and Colin. Oh my gosh, y'all. This is small town drama, is what it sounds like to me. Prosecutors state that Colin had become the target of an online harassment threats after a blogger accused him being involved in the O'Keefe death. Kenneth Brockovich, okay, police chief. Former Canton police chief. Resigned in 2022. Called Brian Higgins after O'Keefe's body was found. 1 week after the incident, while driving past Albert's home, investigators said he allegedly found pieces of red plastic consistent with Reed's taillight. Okay, isn't my understanding, but wasn't the Reed's taillight and all of that, didn't they look for all of that the night? And didn't witnesses state that it was cracked and not broken? I don't know, y'all. I'll hear all this in trial. Adrian Kearney. I'm really bad. I'm dyslexic. I'm doing the best I can. Kearney runs a website on social media, announces accounts under the name of Turtle Boy. Oh, here's Turtle Boy. We finally got to Turtle Boy. Oh my gosh, I've been trying to figure out how Turtle Boy came into this. So Adrian, I'm looking for his picture. He's not on this one. Is he on this one? No, he's not on this chart. Is he on this one? No, he's not on that chart. Okay, he's not on any other charts. Whoa. Got a lot of comments. Yes, her chair light was cracked but not shattered. They claimed they couldn't find the pieces because of snow. Justice didn't take it 2 weeks to turn into O'Keefe's clothing into evidence. Whoa. Okay, let's go back to Aiden Kearney, where he published hundreds of texts and video posts promoting Reed's conspiracy and cover-up claims. He organized a rally in 23 in which he led dozens of chanting demonstrators to the home of people involved in the case. Whoa, snap. That stinks. He posted videos of himself leaving disparaging voicemails on cell phones of people involved. That's harassment. Prosecutors charged him with multiple counts of witness intimidation, some of which were dropped. Others remain active. Oh my lord. Wow. Okay. I'm going to make sure I covered everybody that I could cover, that I could find to cover, because I'm getting a little bit overwhelmed here. Okay, y'all guys, I need to take a mental break. OMG. Oh, what was Turtle Boy's real name? I'm getting to it. Let me get back down there. Aiden, Aidan, Kearney, Kearney. Blogger and Reed supporter accused of intimidating witnesses. Oh, if I was one of those witnesses, I would have filed harassment charges. Oh, here, I'll type it in. I.e. Turtle Boy. Wow. Do I even dare go to Turtle Boy? Do I even dare go over to Turtle Boy? Wow. Okay, y'all. Jump in. Opinions. Justice obsessed. What is your opinion? Is that a decent coverage? A road thus far? OMG. Oh. Oh, man. I have everything blowing up today. Wow. Okay, y'all. Ah, okay, so I'm going to close out everything but this one chart. And let's see if I can do this to. Okay. So if I got the pathway clear. Karen Reed and John O'Keefe are lovers. John O'Keefe adopted his deceased sister and son-in-law's children. Who's taking care of them now? I want to know. So then Karen Reed at a gathering in the O'Keefe home for a football game decided to make googly eyes at Brian Higgins. Flirty much. Sign language, flirt. I know. So she gave a kiss to Brian Higgins and he reciprocated. He is a co-worker to John O'Keefe, along with Kevin Albert, Chris Albert, Brian Albert. Okay. The night in question, those that were in the home, supposedly at the house that night, were, of course, Brian and Nicole, it's their home, Jennifer and Matt McCabe, who were married, and they have connections to Proctor, social, and kids. Okay. Then we have Caitlin Albert, who works at the AG's office. And Brian Albert Jr., who Julie Nagel is a friend, and Sarah Levingston is a friend. My computer's trying to tell me I need to do some work. Then the dog, Jolie, okay, was at the house. Colin Albert was in the prosecutor's sister's wedding. I'm following here. Are y'all following it, y'all? So Julie and Chris Albert are married. Chris Albert is the brother to Brian. Tim Albert, oh, there he is a brother. Kevin Albert is a brother. Oh my gosh. Yo. Okay. This is just a absolute show. But thank you once again, Brandy and Church, for this fabulous flow chart. Without, I'd be totally lost. And when the trial starts, I'm going to start signing, and this is going to be very helpful. Thank you so much. Oh, Lordy, y'all. Lordy, 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 Lordy. I'm trying to get this to come up in size just a little bit. There we go for you guys. All right, any questions? Oh, y'all. Thank you for joining me today in this Who is Who. Thank you so much for commenting, liking. Please subscribe, please, and share with your friends because we will be going live for every day of this trial if it does not blow my brains out first. I'm getting a brain cramp, y'all. Whoa. I'm going to need this chart and I'm going to be taking very close notes. It's going to be hard to take notes and sign, but I'm going to have to rewatch my own live and take notes. All right, you guys. It is now 1:00. We are going to call this one a day because I need to get lunch. I have a 3:00 commitment and I really need to sit down while I have this fresh in my head. I'm going to print out what I just read to you guys. I'm building a little folder so we can keep up with everything. We really need to do that. Let me get back to the comments. You have one what? Yes, I have one. One what? But I am desperately hungry. I need to give my baby girl some medication. Y'all keep her in prayers. This is the first time she's ever been sick. I've never had a sick service dog before. I love her very dearly. Oh, thank you, Ronnie. Let me jot that down. DOCTORTUTU. Okay. I will see what I can do and find on that. Go ahead and post that in our chat as well. Sparkles for everyone. Thank you so very much. I appreciate that. Yes, question. Answer. I'm waiting. Do, 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 do. I could not get that soundbite. I wanted it. I have no ideas. Sparkles, can you answer that? Is that his Twitter? What is that? Because we all want to know. I want to kind of see a little bit of what's happening. I will this weekend. That's his Twitter. Okay. We will, I was not going to really dive into this and look at it as an alternate juror. But the problem with this is, well, I guess I should because, oh, the jury's going to have to look at it like I am. I know more than the jury does, but I'm going to go, it's going to leave my brain. I'm on overload. Um, I encourage you to do whatever you wish. But if you, I'm on the fence 50-50 whether I should just leave it with what I have here and just kind of let it go out the brain and just use it for context. We will. We shall, Sparkles. Or do I go ahead and go against my own rule? And because of the complexity of this case, and I'm wanting to be somewhat educated, which I'm afraid I'm mm, mm. Do I look at this? Do I listen? I know the Brandian Church has done a phenomenal. She's the 13th juror. Y'all go over there if you really want a deep dive. Go in and look at the 13th juror. She does a fabulous, fabulous job, y'all. I'm trying to keep my little mascot in view. She does a fabulous, fabulous job. I will be moving him to this spot right there when trial starts. I think I just may use this as a reference, and I'm so tempted to binge watch her all weekend, but I don't think it's fair if I'm an alternate juror to do that. So I won't do that. I will keep this chart here in play for us as a reference for those who are joining. Everyone on right now, please. I'm not going to be able to be on live tomorrow, but any motion hearings that's on, I will be watching or listening to while I'm gone tomorrow. I may come in tomorrow night and do what's the word I'm looking for? A catch up. I will do a replay of the motion hearing if there is anything tomorrow in court or on Saturday. I really want us to be caught up with everything. Then Monday, we're going to start. I think their court starts at 8:30 or 8. I mean, that's or 9 or whatever it is. It's going to be 7 o'clock my time. We will run about an hour. We will run behind. I will try to start every day 9 o'clock my time. I know it's a little delay for everybody because the business here opens at 9, and that way I can come in at 8:30, get all everything set up. So we will start Monday at 9 my time, okay? Central Standard Time. In that way, what we can do is kind of when they take their little court breaks, we can kind of skip through the court breaks and by the end of the day be caught up. We will, y'all, mods, you guys can hop in and out. Just please, if you're going to hop in and out, please go to our mod chat. So I think Justice Obsessed, if you look in the description of this post, my email is there. Send me an email. I will put you in the chat. Think the schedule is going to be for court is Monday, Wednesday, full day of court. Tuesday, Thursday is going to be their half days. I think they're going to be half days afternoon. And then Friday off. So technically, they're only going to have 3 days of real trial, 3 full days in a week. That's going to be irritating. Hi, TML. Hey, thank you for joining. You can go back and do the replay. Why mail? Why mail? Not Gmail. I'm going to set up a new email and change it, but for now, just use that. They're saying they're going to need 8 weeks for trial. I don't see how that's going to happen. Not right now. I'm getting ready to head off. I am getting ready to jump off because I have to get ready for another meeting that I have on Zoom. It's a business meeting. Welcome, welcome everybody. So what I'm going to do is I'm going to block out for 8 weeks, but y'all, there may not be days that I can be on, but we will play catch up. Why are you wanting to call me TML fan? So what we're going to do is, like I said, so tomorrow I will not be on, at least during the day. If I might get back about 3, 4 o'clock. If that's the case, I will definitely go on tomorrow and catch everybody up. If not, late, um, then we'll do it Saturday. Sparkles, look at chat. I am going to see if I can get some guests to come on and talk with us during this trial situation. I'm going to see if I can do a panel for the first time. We're going to try all this. It's going to be scary doing a panel, but I'm thinking about doing a panel. Okay. Do me a favor, Sparkles, are you on, please? Okay, Sparkles. TML, please understand we've had some really bad trolls over here and I don't know people yet. We will definitely consider that. So Sparkles vouches for you. TML fan. She talks on YouTube about trials. Cool. Are you following this trial, TML fan? The thing that concerns me about this trial is the number of rabbit holes that a rabbit leads, it goes off. I mean, it to me reminds me of a snail trail where you got 30 trails coming off. I have purposefully not looked a lot into these trials because I like to be like an alternate juror where I listen to the trial as a juror would without a bunch of preconceived preconceived notions or opinions. And then that way I can give that kind of opinion. I am not a lawyer. I am going to school for criminal justice. Maybe we'll be a lawyer one day. At my age, I'm not too sure. Sparkles, can you communicate with me in the chat, please? So for me, the biggest thing right now is just trying to come into this with a clear mind. I at least understand who the players are. At least I can have some context. But all my opinions are going to be as a juror and as a layperson looking at this. I hope that we can have fun. I'm thinking about once a week on a weekend night or one, like maybe Friday night when they don't have jury, having what's called a weekly recap. And I may even have something interesting to drink. Maybe not alcohol, but you know how it is. But I'm thinking about doing a Friday night recap and just kind of kicking back, relaxing, and having fun with my mods. Anybody who wants to join. So, are y'all interested in that? AELCO what? What is that? AC, I don't get it. I'm going to my Okay. Welcome? Is that what that is? Okay. So the plan is Monday full day, Tuesday, I think they're afternoon, Wednesday all day, Thursday afternoon. Then on Friday, the plan, and I've got to put this on my calendar, and then Friday, we will plan for the recap. And that's where we all just come in and just have a good time and just relax and just talk about it. I will have my phone connected to the Roadcaster and try to take phone calls. I do have a secondary phone number that's listed in the comments, in the description. Well, that's okay. I can always start it like at 4 o'clock. What time does hubby get home? I can always start it like 4 o'clock and then we can go in from there. You know, we don't have to start like 7, 8 o'clock at night. When I say night, it could be, so I don't know what time you are, but I'm in central time. So, um, we can start it like at 4 o'clock central. That will get those of us who can't come on at night can come in the afternoon. And that kind of can get an overflow of people in the afternoon and evenings. Right now it is 1:12 p.m. where I am. 1:12 p.m. So that's the plan. Monday full day, Tuesday half a day afternoon or morning whenever the court's half a day. Wednesday full day if that's what the court is. Thursday half a day whenever they are, and then Friday we're going to do a Friday fun night. But I don't want to call it that cuz other people do it. So we got to someone else has a Friday frenzy night. So I'm 2 hours ahead of you. So right now you're 11. So what is your cutoff your time? Because so if I go live like at 5, that's 3 o'clock your time. So that I'm just trying to, yeah, and then we'll go to whenever we're done. Okay. So we'll do Friday. We need to come up with a theme that's not something everybody else is doing. Um, but that needs to be kind of something we need to figure out too. Y'all can, if you are in the mods chat. Um, Sparkles, you want to answer? I think it may be an okay, guys. We have had a lot of people, moles, wanting to be a mod, wanting to come on, wanting to do a lot of things. Right now, I will keep you in mind when we do. I'm not upset with TML fan. I will. I wrote your name down. Uh, and I got you. So if we want to do a panel, I don't know. But if we want to do there was a trigger with the mods. Thank you, mods, for doing your job. But if you want to be on a panel or anything like that, I will put a list together. I am very new at this. I've only doing this 5 weeks. This is the 5th week I've been doing this. I am learning. My mods are learning. We are all learning. So all is well. And I want to once again pop this up and say thank you, Randy and Church, for these fabulous flow charts. You are awesome. Bless you for doing it and giving me permission to use it. And we've got our plan of attack for this trial. And we are going to set up guidelines for this trial this weekend, and we'll have it all ready to go. Tell us about criminal justice. Tell you what, why I want to go into criminal justice? Randy Churchwell, correct. Thank you so much. I'm trying to remember names. There's just and I think y'all can understand when you start something like this and you get into a new place, everybody just stopped everything, tons of names, tons of information, and you're like, my head hurts. I'm having a head cramp. So Brandy Churchwell, thank you so very much. Maybe I can connect with you. Um, when I start doing the sign language, it's going to be imperative for my mods to handle the comments because it's going to be very difficult for me to do that and all the comments handling as well. We will all learn and grow together. And I love you guys. You guys have been an angel. You've been amazing. If you have not subscribed, please do so. It means the world to me. When I get to 1,000 viewers, I will not dye my whole head. I know Emily D. Baker did this where she did a color dye. I love the idea. I'm not trying to copy her. I will not shave my head. I am Native American and our hair is very sacred to us as in the sense of, we take good care of it. We don't, I'm letting it grow. It's getting quite long. So I will dye a section of color. We will pick a color and it will be dyed that color, but that's when we get to 1,000 fans. Or I can just dye my eyebrows. We can dye my eyebrows. That'd be fun. But we will do something fun. So help me get to 1,000 subscriptions. Once we get to that, we're going to do what do you think, y'all? Eyebrows. We'll do the eyebrows for 1,000, and then when we get to more, we'll do the higher we get, the more hair gets dyed. Wouldn't that be funny? Aw. It will not be permanent dye because, like I said, I'm very, very protective of my hair, but we will do some fun things. Still haven't fully named little one yet. My Highland cow, although I got 2 of them in there. Heidi, the Highlander, is one of them. So we're looking good. I've got a list for that. We'll probably do a drawing during that. I would like to entertain as well. All right, guys, with that, it is time for me to hop off. I bless you. I pray you have a fabulous day. My mods, mwah, you have done a fabulous job. Why are you so confused, TML fan? Why? Tell us about criminal justice. I want to get a degree in criminal justice so I can work in the justice system. It's that simple. I have a deaf community that does not get access to someone like me who is deaf. Well, I grew up hearing, but I became deaf. I know sign language, and that's something you can't find within the criminal justice. So that's why criminal justice. All right, guys, I'm out. Blessings. Y'all keep the love going for each other. I appreciate you so very much. And till tomorrow, probably late afternoon. All right. Bye bye, y'all.